Well, good morning and welcome. We've got another full and exciting day here in Senate EDNA. Don't all look so enthused. All right, we will open up the hearing on House Bill 1211. Who do we have here to introduce? Anybody here to introduce 1211? Oh, Representative, come forward. I didn't pick you out back then. Good morning and welcome to Senate EDNA.
Thank you, Mr. Chairman, and thank you, members of the committee. My name is Jim Kofalt. I am representative from Hillsborough County District 32, comprising the towns of Wilton, Temple, and New Ipswich. I'm here today to introduce House Bill 1211 relative to the scope of review of state agency interpretations. Essentially, this bill ensures that our state courts exercise independent judgment when reviewing state agency actions without automatically deferring to the agency's interpretation of the law. So you probably are all familiar, at least somewhat, with something called the Chevron deference, which came about in 1984 in a U.S. Supreme Court case, Chevron versus Natural Resources Defense Council. And in that case, a doctrine was established, a legal doctrine was established, which essentially said that if federal statute is ambiguous or silent on a particular point, then the courts would be required to defer to a federal agency's reasonable interpretation, even if the court might potentially come to a different conclusion. So this established a two-step framework, first determining whether the statute is clear, then deferring to the agency's interpretation if ambiguous, and that shaped law for decades. This all changed in 2024 in a case called Loper Bright Enterprises versus Raimondo. This involved fishing regulations, federal regulations, and the Supreme Court explicitly overruled the Chevron deference, overturned it in a 6-3 decision. So in post Loper Bright, courts can respect agency expertise on facts or science, but essentially they have to view the case de novo. So what HB 1211 does is to codify that principle in New Hampshire law. So our state courts often apply deference doctrine similar to Chevron, although not probably to the extent that the Supreme Court did. But what this does is essentially allows agencies to sort of expand their interpretation, and that has the potential to limit individual liberties. So what this bill does is amends RSA 541A. It requires a de novo review without deference to agency interpretations, and it ensures that the courts are free to decide cases independently using standard tools of statutory interpretation. There is also a second section which looks exactly like the first section, but essentially what this is doing is adding the same principle to the canons of interpretation. So this is the jurist's guides to how to interpret various things in deciding cases. That concludes my introduction to the bill, and I am happy to take any questions.
Well, thank you for your testimony. Do we have any questions from the committee? All right, seeing none.
Thank you very much.
J.D. LaValle. Good morning and welcome.
Good morning.
Just turn your mic on, please.
Thank you.
Thank you.
Good morning, honorable members of the committee. I'm J.D. LaValle. I'm here from the Attorney General's office this morning, and I marked down that we oppose the bill, but I have some nuanced comments. I currently serve as the chief of our client counseling unit. In that capacity, I've served as a hearing officer and also advise many of the executive branch agencies on conducting adjudicative proceedings. First, I want to clarify that the AG's office actually supports the first paragraph Roman numeral 1, regarding what the representative just testified about the Chevron doctrine. My colleague, Sam Garland, who is the chief of our civil litigation unit, provided supportive remarks to the House regarding this. We have some technical recommendations, which I'll get to in a minute, but we certainly welcome clarifying that courts and hearing officers should employ a de novo review of statutes and regulations, legal interpretations. Though the state has never fully adopted a Chevron deference, there is case law that makes it a little confusing as to how much deference, if any, state agency interpretations should be due. And this bill would be a welcome clarification. Paragraph 1 of this bill would be a welcome clarification. The concern, however, is paragraph 2 and then the proposed new section on statutory construction. These do not create clarity, but rather inject a little bit of ambiguity. For that reason, the AG's office does not support the bill as currently constructed. So just a few technical thoughts very quickly. There's a typo in paragraph 1, or it appears to be a typo in paragraph 1. Line 5, I believe, an administrative action should probably be, or an administrative action. And then given that this bill is amending 541A, it's recommended using either unambiguous terms or actually the terms already defined within the statute. For instance, rule is defined in 541A, not regulation. Individual might have a different meaning than person, which is also defined in the statute under A1, Roman numeral 8. It's somewhat unclear what a sub-regulatory document is. Again, that might fall under the definition of rule if you go back to the introductory part of the statute. So those are some technical comments. The greater concern to the AG's office is the vagueness of the standard limits agency power and maximizes liberty, which is the paragraph 2. Again, that does not touch on Chevron deference. Rather, it just directs courts and hearing officers to adopt interpretations that limit agency power and maximize liberty, but it doesn't really define liberty. This lack of definition invites potentially inconsistent or subjective application for a bill that's looking to create clarity, and it risks turning statutory interpretation into a potential policy judgment rather than a legal one. Some examples that we were discussing at the AG's office really boil down to the balancing of liberty between individuals. So there's many, many types of adjudicative proceedings, as I'm sure you all know, throughout the state. The requirement or this standard could create confusion for governing areas like consumer protection, licensing, environmental safeguards, or public health. For instance, I've had the pleasure to help advise the Site Evaluation Committee. There was a wind farm issue regarding noise and light limitations. And so balancing the liberty or the freedom interests of the business owner and then the abutters, if they are to be free from excessive noise, free from excessive lighting. So there's a potential that, it's hard to balance whether we're trying to maximize the liberty of a business or maximize the liberty of an individual resident who may be owning abutting land. Similarly, PUC proceedings. There, the Public Utilities Commission is charged with being the arbiter of interest between, the regulated utility and business, residential, industrial consumers. And so I'm not exactly sure what maximizing liberty would require, whether we're maximizing the liberty of the utility, individual utility, or maximizing liberty of an individual ratepayer, residential ratepayer, a business ratepayer, an industrial ratepayer. And then finally, another example would be in the right to know law. There's a lot of balancing that goes into the right to know law and decisions made regarding release of information. And so there's the liberty interest to be free from unwanted invasion of privacy, right? There's a lot of material in governmental documents that is sensitive. And so individuals may have a liberty interest in wanting to have that information protected. Of course, there's also the liberty interest in access and, understanding what the government is up to. And so trying to resolve ambiguity by maximizing liberty actually creates or potentially doesn't create a helpful standard to apply. So those were our brief comments, but I'm happy to answer any questions that the senators may have.
I have one clarification.
Yes, sir.
So you're suggesting, like on line 11, we insert person instead of individuals? Was I correct in hearing you there?
I don't want to make a suggestion, but I think 541A does define person and it includes the word individual. So if you were to amend 541A with this and use the word individual, it does not mean person, and I'm not exactly sure what it would mean.
So if I don't know if you can off the top of your head, but what is the definition of person in 541A? Does it not include corporations and business?
It does, yes, sir.
And would that, in my reading, wouldn't that be contrary to what this section 2 is trying to do? It looks like it's trying to use individual as the person, the human person, maybe not a corporation.
That might be true, Senator. It might bear defining the term individual in 541A.
Okay, thank you. Questions from the committee? Senator McGill?
Thank you, Mr. Chairman. Thank you, Attorney LaValle, for coming and lending your expertise and helping us make this bill better. So my question, I've just got a couple of things. On line 4, change regulation to rule. Line 5, administration to administrative.
Yes,
So
Senator.
far.
Sorry.
Okay.
Yes. Yeah.
If I may.
Sure.
Thank you. And then on line 11, individuals to persons or otherwise define individual separately.
I think that could lend some clarity, Senator. Yes.
Thank
Well,
you.
it would also be on line 19.
Oh, yes, it would be. And last one, on line 12, starting at the end of line 11, as a result of the state statute or rule, period, would that clear it up? If we just change regulation to rule and make statute or rule?
Again, Senator, I think that could lend some clarity regarding regulation or sub-regulatory document.
Okay.
Yes, sir.
And one last
One more,
question.
sure.
Could you suggest how we might clarify on line 18 maximizes liberty for individuals such that it would be more easily interpreted or supported by the AG?
I think that would require a little bit of work, Senator.
Very good.
I don't have ready-made language for you here today, but I think that could require potentially some significant tinkering.
Thank you so much.
Certainly, Senator.
Senator Reardon?
Thank you. Thank you for taking my question this morning. When we talk about maximizing liberty, we're really talking about policy, not necessarily statutory framework, right? To define that is a policy question for us to decide.
Yes, yes, ma'am. I would agree with that. I think that's a policy question. I think that is the thrust of my comments here this morning, is that it's a little unclear what the policy is. And so the paragraph 1 seems to lend some clarity,
Correct.
and the remainder of the statute tends to inject some ambiguity.
Great. Thank you.
Yes, ma'am.
Any further questions from the committee? All right, seeing none. Thanks for your testimony.
Thank you, Senator.
Nino, I'm sorry, I'm not sure I can read the last name. Nino, first name? Nino? Yes, there. Okay. You're gonna have to help me on the last name, sorry.
No problem. Thank you very much, Chairman Pearl, and other members of the committee. My name is Nino Marchese. I serve as the Judiciary Director of the American Legislative Exchange Council, also known as ALEC. I very much appreciate the opportunity to speak to you today about this bill. A little bit about ALEC. We're America's largest nonpartisan, nonprofit voluntary membership association of state legislators. We have about a quarter of the nation's state legislators as our members. And more specifically, as the Judiciary Task Force Director, I handle various civil and criminal justice reform issues. A big bucket is working on administrative state reform and reinforcing our separation of powers framework. Judicial deference fits perfectly into this camp, and this is an issue I've worked on for several years. Put simply, judicial deference is a judicial doctrine which ties the hands of judges and forces them to adopt the legal interpretations made by executive branch bureaucrats. So fundamentally, our members see this as a contravening of the separation of powers. You have a legislative branch, which is supposed to be the exclusive lawmaking branch, judicial branch, which is supposed to be exclusive legal interpretive authority. And this deference doctrine essentially forces judges to cede to bureaucrats where there's no democratic accountability to adopt their interpretations into law. So just like the bill sponsor said, Representative Copal, in 2024, the U.S. Supreme Court abolished this practice. For 40 years, it was in place. Now federal courts are prohibited from automatically deferring to agency interpretations. That decision didn't touch state courts, and deference doctrines were all throughout the states, including New Hampshire. Essentially, in the last 5 or so years, we've seen about 13 states having statutorily outlawed deference. We have about 7 states running these bills this 2026 session, including New Hampshire. And it's really just as simple as putting the baseline authority back in the judicial branch. I think it's important to recognize that courts may still end up at the same interpretation that an executive agency may have seen it. They're not prohibited from doing that. They're just prohibited from automatically having to defer, regardless of how they see the law. And so I think it's an important distinction to make that prohibiting this deference doctrine is simply reinforcing the authority that courts are supposed to have to be the exclusive interpreters of the law. In New Hampshire, you do have deference doctrine established at your Supreme Court level. However, you're one of many states that inconsistently applies the doctrine. A lot of states mandate deference be practiced, and that's consistently done. A lot of states simply permit discretionary authority, and then that's inconsistently done. So there's inconsistency in how it's applied. So the understanding of how deference is going to be applied in a New Hampshire court is really a gamble and uncertain at best. So we commend this legislature and this Senate committee and the sponsors involved for introducing this legislation, for considering legislation to prohibit the practice. This legislation aligns very similarly to an ALEC model policy, the Judicial Deference Reform Act. And we commend you all for taking up this important issue. And I encourage all of you to review ALEC's model Judicial Deference Reform Act as you continue to work on this. And I'm happy to answer any questions that the committee may have. Thank you.
Thanks for your testimony. Do you have any questions from the committee? So I'll give you one. You heard the testimony from the excuse me, Department of Justice. Any suggestions on how we would define the term individual? How do other states do it?
I think individual is more or less commonly interpreted by most state courts, definitely the federal judiciary. I don't think there's much ambiguity on what the term individual means. Further, I would extend that to individual liberty. And while I take note of the gentleman's comments from the AG's office, I would say that the second part of this legislation, when there is still no deference and there's still ambiguity, courts should defer to leaning on the side of individual liberty. I mean, this is basically the civil parallel of the rule of lenity that you have in criminal law, right? When everything has been done properly and all the clean criminal law answers and there's still a little bit of ambiguity, this criminal law doctrine, the rule of lenity, says you interpret in favor of the criminal defendant. You interpret the law in favor of that individual's liberty. I think that's just generally a concept that courts understand. And that is more or less the genesis of why that language has been put into our model legislation. It's not so much a forward guiding principle that drives interpretation in a post deference landscape. It's just kind of there at the back end, just in case you have a very complex, ambiguous scenario. So I don't see the ambiguity that the Attorney General's office sees. That doesn't mean that they don't have legitimate concerns that could come up, but that's my view of the ambiguity in that section.
Thank you. Any further questions? Senator Altshuler?
Thank you, Mr. Chair. Okay, that's as far as that's gonna go. Good enough.
You need a pillow?
I know. Who switched my chair? Like, haha, April Fools. Yeah, okay. In all seriousness, thank you very much for taking my question. Thanks for switching my chair.
I did
And-
not do that.
I receive a lot of correspondence from your organization, a lot of correspondence from your organization and other legislative action organizations. And usually it's my experience that when a national organization comes to town to get involved with a specific New Hampshire related bill, there's an event that has happened that has caught the attention and brings you all here to support or not support something that has happened in the state that then inspires a piece of legislation. What brought you here? What event happened that made this legislation seem really important to push in New Hampshire now?
Sure. I mean, just to be candid, that there was no triggering event that brought my my presence here. The event was that it was up for hearing in this committee, and this is an issue that I worked on as staff for several years. This is a member that various ALEC legislators have worked on for several years. That's why it's been passed in 13 states in the last 5 years. So simply the fact that states are motivated to codify the prohibition of deference post the Supreme Court, the U.S. Supreme Court doing so, has launched a national campaign on part of state legislatures to do this, to make this reform simply because, for a matter of principle. And, when we see legislation moving through states, we want to be able to express our members' positions on issues. And so I'd say that my testimony today is provided just for a matter of principle rather than a specific isolated triggering event.
Any further questions? All right, seeing none, thanks for your testimony.
Thank you.
Brian Norman. You want to switch chairs? Not with me, but.
No, with you.
Go ahead, sir.
Mr. Chair, members of the committee, my name is Brian Norman, and I'm the Director of State Affairs at the Goldwater Institute, here to testify in favor of House Bill 1211. The Institute works in courtrooms, capitals, and communities nationwide to protect constitutional rights and empower individuals to live freer lives. House Bill 1211 simply states that hearing officers and judges may not defer to government agency interpretations of laws or their own regulations. And this is an issue we've seen across the nation. Government agencies often apply overzealous interpretations of laws or their own regulations, which serve to expand their own power in enforcement or regulatory proceedings. And in some states, these generous interpretations are then upheld by deferential courts, which can expand agency power in a manner that often goes against legislative intent. This dynamic effectively turns government agencies into lawmaking entities that step into the constitutional domain of the legislative branch. Moreover, judicial deference creates a system in which the government has a built-in advantage over average, everyday citizens in court. And this bill just rectifies that fairness imbalance and just truly prioritizes fairness in the justice system while also prioritizing the legislator's prerogative to make law. In fact, in 2024, as some of the previous speakers have noted, the United States Supreme Court finally recognized that judicial deference is fundamentally unfair and that courts have the sole constitutional duty to interpret law by overturning Chevron deference in Loper-Bright v. Raimondo. But this decision does not apply to state courts. State administrative law is a creature of state administrative procedure acts. And so New Hampshire courts can still defer to agency interpretations of law and regulations. So House Bill 1211 just ensures a neutral playing field by requiring courts to review agency actions without deference. And this provision just ensures that judges are neutral arbiters in favor of justice rather than parties biased in favor of administrative power. The legislation's presumption in favor of limiting agency power creates a further check on the administrative state's ability to infringe on individual liberties and protects the legislature's ability to make law. And in 2018, Arizona actually became the first state in the country to adopt this reform by statute based on language developed by the Goldwater Institute. As my colleague from ALEC noted, numerous other states have since followed suit via legislation or litigation, particularly in the last 3 years. About 11 states, I believe it's 11 states, have adopted similar legislation in the last 3 years alone. So for these reasons, the Institute urges you to support this bill, and I'd be happy to answer any questions that you might have about the legislation.
Thank you for your testimony. Do we have any questions from the committee? Senator Altshuler?
Thank you, Mr. Chair. Thank you, Mr. Norman, bless you, for taking my question. Similar question to the previous person testifying. It looks like you're the second big gun to come into New Hampshire. What's happening in New Hampshire? Is there a case pending that has, your lights flashing? What's happening here that has brought your attention to our little state?
Senator, thank you for your question, and thank you for considering me a big gun. I don't consider myself a big gun, but there is no triggering event that brought me here. We've worked on this project, reforming judicial deference, since 2018. As I mentioned, I think Arizona was ahead of the curve, and we were pushing that reform before Loper Bright. This has been a project of ours for a long time. So generally, my role is to help legislators who are interested in this issue pursue the legislation and educate lawmakers based on our experience with the reform in states across the country. So there's no triggering event to answer your question.
Further questions? Senator McGee.
Thank you, Mr. Chairman. Thank you for coming. Welcome to New Hampshire. Thanks for lending your expertise on this. Would you say that this passage of this restores judicial autonomy?
Yes. Senator, like my colleague from ALEC mentioned, there is some ambiguity in the precedent in New Hampshire. I have a quote from N.R.E. Weaver from 2003. Statutory interpretations are entitled to substantial deference, but the interpretations of a statute is to be decided ultimately by the courts. Pretty ambiguous sentence right there. I think this clearly reasserts the judicial branches. This legislation clearly reasserts the judicial branch's role and states clearly their job is to interpret the law kind of regardless of what the agency wants. Now, that doesn't mean they can't find the agency interpretation persuasive. They can give weight to their expertise, but at the end of the day, it is the judicial branch's responsibility, their sole responsibility, to interpret the law, and this bill states that clearly.
Thank you.
Further questions? All right, seeing none, thank you.
Thank you.
Rob Barry. Morning and welcome.
Good morning, Mr. Chair, members of the committee. My name is Rob Barry. I'm General Counsel to the Division of Medicaid at DHHS, but not here to speak about a Medicaid matter. I was asked to come speak about a New Hampshire hospital issue that might be implicated by the second part of the bill. So this is not addressing the first paragraph, but the ambiguity that was spoken of by the DOJ representative. So as you know, in the New Hampshire hospital system, individuals can be involuntarily committed through a court process. And once involuntarily committed through that court process, the hospital has certain administrative hearings that might occur as a result of an individual being in the system. Two of those processes are what we call HEM 306 hearings, and that's the administrative rule, but that refers to the involuntary administration of medicine if someone is refusing to take medication and is experiencing a psychiatric emergency. And the other one is if someone has been discharged on a conditional discharge, but is not complying with the terms. So in order to enforce the terms of a conditional discharge, that results in an administrative hearing. And the ambiguity here is if somebody is brought back into the hospital, they have a right to appeal. And of course, with the second paragraph here, it may implicate the tension that naturally exists between liberty of being outside of the hospital on a conditional discharge or being brought back and admitted back into the hospital. And as shifting back to the HEM 306 hearings, which are, of course, involuntary administration of medication, I think that's pretty self-explanatory about the liberty interest there. Both of those hearings are subject to a clear and convincing standard of proof on the department, which is a very high burden. And we think that adding this would create an even more substantial burden on the hospital in terms of providing much needed care to individuals who are experiencing psychiatric emergencies in many circumstances. And with that, I'll take any questions.
Any questions from the committee? Sarah Roach?
Thank you, Mr. Chair. Thank you very much for taking my question. Could you walk us through a practical application where this proposal would hinder doing the work? So patient is involuntarily admitted and walk us through what happens next. We know 72-hour hold.
So I think it would more apply after the court process.
Okay.
So they've
If
been,
you want to start there. I
Okay.
was hoping you could start us like, here's how it's playing out, like in real time, particularly for the caregivers who are watching and also creating information or creating the data set that is going to be used in the court hearing.
well, because the administrative hearings happen after the individual has been involuntarily admitted through a court process. So the due process has happened. They've had their day in court. They've had a commitment through a court process, through the probate court. Where this happens is a psychiatrist has prescribed medication to an individual. They're refusing to take the medication. They're decompensating. They're violent. They're having issues on the unit. They're a danger to the staff. They're a danger to the patients. They're refusing to take sometimes medication to treat other conditions like maybe diabetes. It can be a very severe issue. So when we have these HEM 306 hearings, for instance, we file the petition. They have to be held within a certain amount of time. I think it's 2 days, maybe 3 days. It's in the rule, and I can get you the specifics. And the patient has a right to appeal, and if they appeal, they are appointed counsel. Counsel comes, represents them, and the doctor has to present what medicine is being asked to be prescribed, what the effect is, what the side effects are, and why a reasonable person would take this. Oh, and also what a psychiatric emergency is. And then the hearings examiner has to make a decision whether or not, it's granted. And it's granted for a very specific period of time. It's not forever. And with that, the hospital has the ability to administer this medication through emergency means. Now, when we have this order, the hospital tries to get the individual to take it voluntarily at this point through less invasive means. But of course, if they still refuse to take it, then you can resort to more invasive means through injections and such. But usually by then, they might hopefully understand that now it's time to take it through oral means or whatever. But so that's generally the process. And it does expire after a while. And you're only allowed to get, I think, 2 of them per admission. So it is limited. But what this might do is, of course, there's a very substantial liberty interest in not being forced to take medication.
Of course.
And that's what we're concerned about with this bill, is creating more ambiguity with that in this situation.
Follow-up, or
I'll set. Thank you.
Senator McGee?
Thank you, Mr. Chairman. Thank you for taking my question. My question is specific to line 8, at the end of line 8, where it says, after applying all customary tools of interpretation. Wouldn't that basically preclude all the cases you're describing? Like almost every single one would be resolved through customary tools of interpretation? And it clearly states this provision doesn't apply until after that. So how many cases would really be in play here?
I mean, that's a question that I wrestled with. And I mean, I don't really know the answer to that, because I think you can make the argument that no cases would ever be in play. But at the same time, there's an ambiguity there. I'm honestly not sure what that provision means. Because it almost suggests that there's circumstances where there could be a legal, and I'm going to put air quotes, tie. And I don't know if that can happen. I don't know if that's the intent, but paragraph 2 is just a bit of an enigma to me from a legal perspective. I'm not sure what it means or how to interpret it.
Further questions? All right. Thanks for your testimony. Our last person is Sarah Scott. Ben, if you want to check the other sheet, see if there's anybody else. Good morning and welcome.
All right. Good morning, Mr. Chair and members of the committee. Thank you for the opportunity to testify here today. My name is Sarah Scott, and I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. I'll keep this brief because I think everybody before me has stated a lot of the points already that I was going to make, but we're here today in support of HB 1211 at its core. We think that HB 1211 is a simple but powerful principle that laws should mean what the legislature says they mean, not what an agency later decides that they mean. So we think this bill overall restores balance. It ensures that when the law is unclear, decision makers apply the traditional tools of interpretation, and then if there's any doubt remaining, they resolve this in favor of individual liberty rather than expanded agency power. I would say that this isn't just an abstract legal issue. For a lot of small business owners, for example, that uncertainty can mean delays in hiring or expansion while they go through this process and figure it all out. For families or community organizations, it can mean unexpected compliance costs and dealing with navigating shifting rules without any clear guidance. So this bill really would give people confidence that the rules won't change without any kind of accountability. I think this further solidifies that the legislature has the power to write these laws, and the court's job is to interpret them as the legislature has written it. And I would also say that this is not an anti-agency bill. Agencies do play an important role in implementing the law, but the implementation should really reflect what the legislature has written and make sure that the rulemaking process doesn't become legislation by another name. So I think overall this bill just clarifies a lot of that existing uncertainty and ensures that we have established clear boundaries between the role of the judicial, legislative, and executive branches. I also would want to bring up a couple of things. I know that Senator Altshuler mentioned any kind of a triggering event. While there's not anything currently happening, I do want to point out that the initial Chevron deference case initially did kind of start from a case here in New Hampshire dealing with fishermen that were fishing off the coast here. And there was an agency rule that required them to have somebody on board their boats at all times, essentially doing monitoring, and the boats were forced to pay for that. So this was a huge issue for the fishing industry off the coast in New Hampshire and Maine. And while the overall Chevron case ended up being about different fishermen. It was started by some fishermen from here in New Hampshire. So I think that's why there's particular interest, at least for me personally. I've spoken to some of those fishermen that were involved in that, and this was a very big issue for them. And I think that having won that case at the federal level was really their initial goal with this. But I think it would be important for us to continue that work here at the state level also. But I'm happy to take any questions.
Thank you for your testimony. Any questions? Senator Altshuler.
Thank you. Thank you, Mr. Chair. Thank you for taking my question. Thank you for answering my first question beforehand, no triggering event. So I can move right on to the second question. So in what may be different here in New Hampshire from the 13 other states that have already done this, is that in New Hampshire, our rulemaking is done with legislators, right? So it's not an agency only function. So it's, there are a lot of legislators and a whole host of alternative legislators who haul it all up here to do the rulemaking. So the rulemaking here is not necessarily a sole function of a department, which seems to be the crux of the argument, is that the rules have to be more in line. If I'm understanding your testimony and everyone before you, that the rules should be in line with the laws as passed and intended. Correct?
Yes.
Am I on the right track there?
Yes, thank you for,
Great.
I'll just clarify there. I would say that this is complementary to our existing rulemaking process, which I do agree is substantially better than what the rulemaking looks like in a lot of other states. I would say this is a helpful addition to that to continue to emphasize that protection of rights.
Okay, but you would agree that our rulemaking process is fully enmeshed with legislative intent, because our legislators who made the laws in the first place are now interpreting how that should play out in rules. So it's not a removed function of government. It is right in line with the legislature. So I mean, just to make sure that there's an understanding with your organization that New Hampshire does it differently than perhaps Arizona. Unfortunately, I'm not familiar with how Arizona makes their rules, but nonetheless,
I'm not
we
familiar.
may be unique in that way.
Yes. I'm
Thank
not
you.
familiar with
Yeah.
how Arizona's rulemaking process operates. I'm only familiar with New Hampshire's. But I still think that this legislation, in talking to a lot of the lawyers involved in this process, there's still a lot of room for agencies to implement this type of rulemaking. And I would also say that even though we do have a rulemaking process, sometimes that rulemaking process is not necessarily extensive in the case of like what the intent of the legislation was. Sometimes these rulemaking processes come up years later, and it might not be anything related to the initial intent of that legislation.
Further questions? All right, seeing none, thank you. Anybody else? All right, seeing none, we're going to close the hearing on House Bill 1211.
You started going in my face.
I know, we'll get it back. All right, we'll open up the hearing on House Bill 1269. Representative Long, yep, okay. You are recognized to introduce.
Thank you, Mr. Chairman, members of the committee. I wasn't planning on speaking on this bill today, but since Prime Sponsor is not here, I'm introducing it. So I will try to answer any questions the committee has, but I am probably not the best person to do that. I think there are other people speaking who would be better at that. But this bill simplifies the requirements for people with out-of-state licenses to become acupuncturists. This current law has this additional requirement of a baccalaureate, registered nurse, or physician associate degree that only applies to people coming from who have a valid license in another state. And they have to have that in addition to meeting all of the existing requirements for someone who gets licensed in New Hampshire. So that's just an unnecessary requirement. and this streamlines the requirements by lining them up with what someone already licensed in New Hampshire would have. And then the rest of this, I believe, is just administrative changes. One thing is adding a certified acupuncture detoxification specialist to the board. I think because that's a little bit different than standard practice of acupuncture. It's something that there's a need for representation of that particular subspecialty on the board of acupuncturists.
Thank you for your testimony. Any questions? All right, seeing none. Elizabeth? Hit your button. Nope, till the red light comes on.
Oh, okay.
There you go. Thank you.
Thank you, Board Chair and Senators, for having me speak for your committee today. And thank you to Representative Long, who was able to step in for Representative Schmidt, who's delayed this morning. So I am Elizabeth Ropp. I am a licensed acupuncturist here in New Hampshire. I'm also a trainer and a general supervisor for acupuncture detoxification specialists. And I'm speaking in support of HB 1269. I hope my testimony can help you understand the changes being asked for. I approached the Acupuncture Licensing Board and the State Association and asked for these changes, and we worked on this together. So what you have before you are changes that we all agreed on and were amended by the House. So this will create pathways for reciprocity for licensed acupuncturists, and it will expand our licensing board and provide a seat for the acupuncture detoxification specialists, which is another tier of certification that New Hampshire has offered since 2017. And it will allow the licensing board to clean up some burdensome rules around training manual standards for acupuncture detoxification specialists. And it updates an organization's name that oversees the national certification of acupuncture. So currently, New Hampshire is one of only 3 states that require licensed acupuncturists to have a baccalaureate degree, also a nursing degree. And that's not common. The majority of states, and I've looked at all of them, will simply defer to approved, accredited schools to set the standards on who their applicants are. And the schools tend to accept students who have an associate's degree or 60 credit hours. So this bill has made it really difficult to allow licensed acupuncturists who've gone through the same training I have to get licensed here. And just for background, my bachelor's degree is in liberal arts. It was a complete career change when I pursued the field of acupuncture. So I'm joined today by the president of the acupuncture board and one of the AcuDetox specialists. Adding a board seat is important. Ear acupuncture by acupuncture detoxification specialists is the future of acupuncture in New Hampshire for a couple different reasons. The ADSs are set to outpace the licensed acupuncturists within 3 to 5 years. And not only that, if you're following the U.S. Department of Education, many acupuncture schools will probably be closing because of the Grad Plus loans. So the Department of Education is looking at the schools that graduate students with highest debt low-income ratios. And acupuncture schools and naturopathic schools we're not one of the worst. Our schools are the worst. And so they will be losing access to student loans, and that's going to affect the future of licensed acupuncturists. Does that make sense? Okay. And then the last point is about the board-approved trainings. So what qualifies as a board-approved training for ADSs now is very burdensome. I'm a trainer under a board-approved training here in New Hampshire. Like, the amount of additional work to get that training approved was like no other. Current members of the licensing board are willing to rewrite some of these rules, but they're hamstrung by the statute, which requires that any board-approved training manual must meet or exceed the 2017 version of the National Acupuncture Detoxification Association's training manual. And just to fill you in on what has happened in the past, That exact manual was submitted to the board a few years ago under a different name, and it was rejected as an equivalent to itself. My mentor wrote the manual. She tried to have it approved under a different name because it was her manual, and it was rejected. She would be here testifying to this if she could, but she passed away 2 years ago. But I've asked the board, can you rewrite the rules so that we can focus more on safety and following the statute and give trainers some leeway on how they approach their trainings? So, any questions?
Thanks for your testimony. Any questions from the committee? Oh, looks like you did a good job. Thank
Oh,
you.
thank you so much.
Rachel. Rachel Bolton? Good morning.
Hi, good morning. Good morning, Mr. Chair and senators. Excuse my voice, I'm recovering from a cold, but I had to be here today. My name is Rachel Bolton. I'm representing the New Hampshire Acupuncture and Asian Medicine Association. I'm currently their acting president. So representing members, are licensed acupuncturists in this, representing licensed acupuncturists in the state of New Hampshire. NAHAMA supports the efforts to maintain high standards for acupuncture practice while improving efficiency and reciprocity with other states. This amended bill will clarify licensure pathways, align terminology with national standards, and ensures ongoing public safety. And we are in support of the bill. I don't have quite as much to say as Elizabeth because she did such a good job covering most of it for me, but I'm happy to answer any questions.
Thanks for coming today. Hope you feel good. So,
Thank you.
any questions from the committee? Looks like we're good. Thank you.
Thank you.
Director Jurius is here. Did you want to speak or, okay, come on up. You had wrote questions, so I didn't know.
Oh, yes, thank you. I'm happy to take any questions, but I realized I did have one extremely EDNA level clarification. Just for the record, D. Juris, Executive Director, OPLC. I would like to respectfully request that the committee consider the board member composition instead of adding a member, which would bring the board to 6, which is an even number, which is generally not our practice, that within the scope of the statute, I have it up here on my phone, but that we would consider where it says 4 acupuncturists appointed by the governor with the advice and consent of the council. It could be one of whom is a certified acupuncture detoxification specialist, or 3 acupuncturists and then one of this other certification, so that we got 4 licensed professionals and a public member to make 5. So instead of, I guess the simplest change would be to change 328 G3 Roman 1A from 4 acupuncturists to 3, and then include the language as drafted.
Okay.
Other than that, happy to support this and implement it as drafted.
That makes sense. Questions from the committee?
Thank you.
Seeing none, thank you. Anybody else that would like to speak on 1269? All right, seeing none, we're going to close the hearing. That's right. All right, we will open the hearing on House Bill 1286. May papers here. Representative Drago, come on up and introduce. Good morning and welcome.
Good morning, members of the committee. My name is Mike Drago. I represent the town of Raymond, and I am introducing HB 1286, which kind of got its own name of the Dental X-Ray Ultimatum. Like most bills that we put in, it comes from constituent request or personal experience. This one was personal experience, and I thought something needed to be done, and here it is. I'll briefly talk about how it came about. When my wife and I first got married, we did not have dental insurance. And so when you go get your cleaning, and then you get your x-ray, and then the dentist comes in to check your teeth at the very end, that bill gets pretty expensive. So we would try to push off the x-ray as long as possible just to help save some money. What we found is you could go a year, and then they start to get a little pushy. The most we ever got to go was 2, and then we'd have to give in and pay for the x-ray. Well, fast forward now, we have dental insurance, but we have kids, and we don't think our kids, or we don't want our kids to get x-rays at the time of routine cleaning, expose them to radiation when otherwise they're feeling okay. So we've tried to push it off. Same thing, we can go a year or 2, and then we don't have a choice. So we've bounced around to a few different dentists because after a while you get refused care. You're not allowed to stay in the practice. And the final straw for me was after we had gone to a new dentist. I think we had gone to 2 cleanings, so roughly a year, and I was up front trying to make the appointment for the next cleaning, and they had said that you can't have a cleaning until you get your x-rays. Knowing the drill, because we've been through this multiple times, I said, okay, we'll just get them at the next appointment. And they actually said, nope, you have to come in for your x-ray first, and then we'll make you a cleaning appointment. They won't even clean our children's teeth until they got their x-ray. So that to me is a huge red flag, and that's something I had issue with. And so why do I think this is important? Regular dental cleanings have been shown to prevent, cavities, gum disease, many things to do with oral health. And if you do the routine cleanings, it often saves you huge expenses in the long run with big dental procedures just by taking care of your mouth. But not only does it help with dental hygiene, but it's also good overall health. It helps decrease the risk of heart disease, stroke, diabetes. Taking care of your mouth has been shown to basically give the whole body a better, picture of health. So by not getting an x-ray and being refused care, we're basically saying the rest of your body health doesn't necessarily matter as much. And again, I have an issue with that. If you go to your primary care for a physical, he's not going to just order an MRI on your knee to make sure you don't have a torn meniscus. If you don't have any other issues, he's just going to, do the normal blood pressure, eyes, stuff like that. Even though he can't see everything else, he's not going to order all these tests. And that's what's happening at dentists. So, and take it a step further, maybe he says you have high blood pressure. It's still your choice if you want the blood pressure medication or not. He might say you need to go in for blood work. It's still your choice. You're not going to be refused care at the doctor. You're not going to be told you can't come back for a physical the next year. The dentist is simply going to say, you're as healthy as I can tell. And that's that. At the end of the day, it's still the patient choice. So why is this so important to my wife and I? And I'm telling you that a lot of people around the state are in support of this bill, and they appreciate that I put this in. X-rays are not safe. Safer than they used to be, but they still carry risk. And it's certainly true in children. The cumulative effect of radiation has been shown to increase certain types of cancers. So in my mind, if something's not completely safe, it should not be forced upon you. And that's what's happening. Actually, just in time, the American Dental Association, their journal, in January of 2026, they had a part that said children and young adults are more susceptible to the effects of radiation, so radiographs should be ordered judiciously. Just came out 3 months ago, right in time that this bill was being introduced. Also, a 2019 study from the same journal concluded that low-risk adult patients, routine radiographs often provide minimal additional diagnostic benefits and can safely be deferred without compromising clinical outcomes. So there is evidence in these journals that it does cause harm, or it could, and they should be used sparingly without really any evidence of detrimental treatments. So why are x-rays forced? Well, the 2 reasons that I could tell was, one, dentists can't tell between your teeth. So if they're saying you're healthy, they need to make sure you're healthy. If they miss something, they can be sued. And so this is part of my bill, was basically to allow for them to be protected. I personally believe if I refuse an x-ray, I can't go back at the dentist and say, well, you missed something, and I can sue them. So this bill protects them in that way. And the other reason is, and this, actually I stumbled upon this and it was actually kind of concerning, but dentists can risk losing their licenses because our current law says that they have to follow the current recommendations of both the CDC and the American Dental Association. And that's concerning by itself, the word current, because we know how throughout COVID pandemic, how current recommendations continue to change. And we tie our medical professionals' license to the current recommendation. But the law says failure to follow these guidelines can risk discipline by the licensing board up to the non-renewal of their license. So this bill also puts in that a dentist cannot be punished if the patient refuses. It's unfair to the dentist, but we also need to protect the dentist and the patient at the same time. So in closing, the last thing I'll talk about is informed consent. And I'll just read it off to you. It's a crucial process in healthcare and research where a person voluntarily agrees to a procedure. That's key, voluntarily. Treatment or participation after a provider thoroughly explains the nature of the action, potential risks, benefits, alternatives, and consequences, ensuring they understand and can make, another key part, a well-informed decision, meaning they're deciding for themselves. Protecting patient autonomy and legal standards. Key elements include the provider's disclosure, the patient's capacity to understand, and again, their voluntary agreement. Everything's voluntary, everything's a decision. And by tying one service, a cleaning, to an x-ray, you're removing the informed consent of that patient. And this informed consent is the ethical cornerstone rooted in patients' rights and autonomy, and dental patients across the state are being denied that. And so I'm here hoping to change that issue.
Thank you for your testimony. Do we have questions from the committee? Senator McHugh?
Thank you, Mr. Chairman. Thank you, Representative Drago, for coming and taking my question. Line 4, could we change the shall to a may?
Can I actually grab? I gotta grab.
Oh, yeah, sure. It's the part where it says the dentist shall require the patient to sign a waiver of liability.
Yes, thank you for the question. I am okay with that. We went back and forth with this in the House, and I believe it should be up to the dentist. I don't want to mandate on the dentist how they handle this, and I agree with you. So I'm okay with that. Yep.
One last question.
Follow up?
Would you believe I experienced the exact same situation on multiple occasions? And my dentist is a close friend.
Thank you for the question, and I would say yes, because I think it's very hard to find a dentist that will not allow you to get a cleaning without an x-ray.
I went ahead and got the x-rays because he's a good friend and didn't want to change dentists, but that would have been the alternative.
Yep, that's what everybody experiences.
Thank you.
Senator Reardon?
Thank you. Thank you, Mr. Chair. Thank you for taking my question. If I'm hearing your testimony correctly, you're saying that dentists are doing this because they have to follow the guidelines of the CDC and the American Dental Association, and they recommend that this happen?
Yes, thank you for the question. The American Dental Association has a bunch of charts and graphs. I don't have them all memorized, but it goes by age and symptoms or whatever. But yes, basically they say every couple of years you're supposed to have the x-rays done. And because it's recommended and our state law says you could be punished if you don't follow the guidelines, here we are.
So it's possible that we could change our law here to say that there's an exception to dentists having to follow those guidelines in the case of, x-rays every 2 years. Would it accomplish the same thing?
It would probably accomplish the same thing, yes.
Further question? Senator Altshuler? Oh, one more?
I just have one more of a comment than a question. I too have had the exact same experience at my dentist, and I have 3 children who are well past adolescence now, who had fluoride as kids, have never had a cavity, but have had bite wing x-rays every 2 years their whole lives. Thank you.
Senator Altshuler?
Thank you, Mr. Chair. Thank you for taking my question. When your physician was explaining or asking, would you consent to the x-rays, and you were denying that you wanted to do that, did they explain a standard of care to you? That they were like was there any reasoning about what the standard of care was before they're delivering dental services to you and your children?
To be honest, no. But we've seen quite a few dentists now because we bounce around the choices. Either you get them or go somewhere else. But the first few times it was the hygienist who, not in a typical situation, the hygienist just says, you're due for x-rays, and people say yes or no or whatever. So no, I had the debate with the hygienist a few times. The one time I did talk to the dentist, I said, what's the deal? And he said, well, you could have an abscess and die. And I said, well, I think you're going 0 to 60. If I have an abscess, I'm sure I have some other symptom. I just don't go to bed and not wake up the next day. So, and that was basically the end of it. But yeah, no, there hasn't really been a lot of, other than it just needs to be done.
Okay, so that wasn't explained at all. Any standard of care?
No.
Okay.
That's it.
Yeah.
Senator McGill, I'll get to it.
Thanks.
All right, Senator Reardon.
So my last question that I have is, so in your bill, it kind of gives a blanket immunity to a dentist. If you've decided not to have x-rays at one time, that you can never sue that dentist. It doesn't limit it to something that could have been determined from that x-ray. It's just that you can't sue them. Is that correct?
Yes.
Okay, thanks.
Further question? All right, seeing none, thank you, Representative.
Thank you.
Dr. Rosado. Good morning. Hit your button, turn the red light on there. Perfect, thank you.
Sorry. Good morning, everyone, and thank you, Mr. Chairman and honorable members of the committee for having me here today. I'm Lori Rosado. I'm a general dentist here in Concord, New Hampshire. Been practicing over 30 years in Concord most of my life, practicing here. I'm here in opposition to HB 1286. I won't define it again. You heard what the bill is. You know, I can give you so many personal stories of why x-rays are necessary, especially for children. I can also understand why people don't want x-rays, you know, so there's both sides to the story there. But, you know, I want you to know that they're not just an optional convenience. I think you all know they are a very important diagnostic tool. They don't just find decay, but they also find pathology. When we talk about children's teeth, you know your own teeth, how big they are and how small a child's tooth is. Decay in a child's tooth is going to travel fast, and it can become serious. I can tell you a couple of stories. I'll tell you one quick one where my husband's an oral surgeon. We met a dentist at his office on a Saturday morning. It was a grandfather with a child, and my husband got out of the car, went in the office to see them. The grandfather's carrying the child, the 8-year-old, and he said to him in the parking lot, "What's happening here?" And he said, "Fever. She's really lethargic." He said, "Put her back in the car, go straight to the ER. I'll meet you there." From a cavity that went undiagnosed due to no x-rays, this small little cavity, and it was the only cavity in that child's mouth. This cavity created sepsis in the child. I know that's a drastic story, but when you look at the very small amount of radiation for that little x-ray, the damage that went the other way from not having a small x-ray is just not worth it. Not worth it. A child can die. We had it happen in Maryland, Diamante Driver. The story went throughout the whole country, how this went undiagnosed, and it was very sad, all from not having an x-ray. So, you know, I don't want to say you have to have x-rays, you have to have x-rays, but there is a limit and there is a standard of care. There's not just a standard of care from the American Dental Association, it's also from every dental school. You're not going to find a dentist in practice that isn't taught that you can't stretch it. Certainly, we get nervous at the 18-month mark, certainly never past 2 years, especially for children. And that is our biggest concern. I had a hygienist once on a patient that didn't want the x-rays for the child. It had been 18 months and she was scaling and a piece of the tooth just came flying out. The mother got upset, said she broke her tooth. We took an x-ray at that point, and there was a big black hole under the tooth that you can't see. You look in and you see this beautiful white tooth. Underneath is a black hole that you don't know is there, but as soon as her scaler touched the tooth, it caused the tooth to cave in. So, you know, again, I can go over many, many situations, but we want you to know, most importantly, that we take the x-ray so it doesn't become something more serious, something more costly, something more traumatic. We don't want a two-tiered system where you have some patients that don't get x-rays and some patients that do, and the patients that are not getting the x-rays think because they floss every day and their mouth looks really clean that everything's perfect, because there's hidden things underneath. And I can tell you that, you know, with many more stories than I've already given you. So then we come to the waiver. In a court of law, most of those waivers will not hold up. You know, a patient cannot sign their rights away. They are not the dental professional. So in a court of law, the dentist is going to be at fault, regardless of anything that the patient signs. So again, another reason why a dentist is never going to let these standards get stretched and ever going to practice under the standard of care. In conclusion, I just want you to know that, you know, the public's trust would be at stake here, and that this weakens the safeguards that protect our patients here in New Hampshire. Any questions?
Senator McGill, thank you for your testimony.
Thank you, Mr. Chairman. Thank you, Dr. Rosato, for coming and sharing your perspective. The Diamante driver case came up during consideration of pediatric standards for sedation, and that we had extensive discussion on that. And as I recall, that was around 20 years ago. And
Yeah, somewhere around 2010, 2012.
Yeah, it might have been
maybe a
further,
little
further
earlier.
back.
Yeah.
But as I recall, the case had something to do with neglect and no coverage, no coverage by Medicaid. And a lot of that has changed since then. It wasn't a matter of refusing an x-ray. It was just no
Right,
no
but not
care.
having an x-ray either, because not having the care, right? So you look in the patient's mouth, everything looks good, but there's hidden things underneath. So someone like a child like Diamante Driver, the parent could be looking in the mouth and saying, oh, his teeth look great. But underneath, there's this hidden thing happening, and eventually catastrophe strikes, you know, so that's again, that's a drastic situation. I don't want that to become our standard of care. It's just to let people know how bad things can become. And then when I saw this case several years ago, watching a grandfather carry the child because they're so lethargic, that was my witness of, my gosh. And that was after the Diamante case, but it triggers you to know, like, you know, the children, they're at the you know, we have to be there to protect them. You know, we're the dental professionals. Not everybody's going to understand how serious a tooth can become. For children, it's not a heart disease thing. It's not a diabetes thing. I mean, it can relate to their diabetes, but for children, it's much more serious.
Follow?
Thank you, Mr. Chairman. Thank you for that and for taking another question. I want to talk a little bit about how this is analogous to medical practice, non-dental. If you have symptoms of upper respiratory or something in your lungs or something that could be pneumonia, could be something else, if you're symptomatic, doesn't the patient have the right to say, to self-determine whether they want a chest x-ray or not? So chest x-ray is something we hear a lot about, more radiation, don't have them if you don't need them. Yeah. But if you're symptomatic, shouldn't the patient be able to self-determine and say, no thanks, treat my symptoms?
Tough one there, you know, because things can go undiagnosed without the proper x-ray. You know, I don't know a dentist, especially if someone comes in symptomatic in dentistry, they're not going to do anything without an x-ray.
One more.
Thank you. So I'm just concerned about I'm very concerned about dental health and how it relates to medical health. So I support good dental health, and I'm a compulsive flosser thanks to my good friend, my dentist. But the phrase "not an optional convenient," isn't any care really optional and up to the patient or the patient's parent?
Absolutely. They can just walk out and not have any care. I would agree with you there. But they can't expect someone else to do the care based on their knowledge and not the professional's knowledge.
Thank you.
No, good. All right. Senator Reardon?
I'm good.
Nope. Senator Altshuler?
Thank you, Mr. Chair. Thank you, Dr. Rosato. Can you repeat that last phrase?
if a patient comes in to see a professional, they can't expect the care to be done based on the patient's knowledge and standards and not on the professional's knowledge and standards.
Thank you very much. That kind of goes to my question in that, so this bill was brought based on a personal experience. And so I'm going to use my own personal experience because I was just at the dentist on Monday. As a person, I brush and floss and rinse and with fluoride, and I do all of those things myself. But then I further choose to go to a dentist's office twice a year, sometimes more, depending on what's going on, to consult with a professional dentist about how does this all look? Because I'm not a dentist. I don't know. I can do all the
Understand.
things recommended, but I don't know. And also, we have a dental hygienist in the family, and you can have her look in your mouth at Thanksgiving, and she will say, I can't tell. You have to go to the dentist. And so the standard of care is what you're choosing, correct? When a patient goes to a dentist, it's not necessarily a la carte. You're asking for the dentist's full scope of professional training to deliver health care that's set at a standard of care by the American Dental Association and what was the second one? The CDC, correct?
Correct.
Okay, so it's medical care. You can choose what you want, but a physician doesn't have to necessarily offer a la carte care.
Correct. Are you referring to dentist?
Yes.
In that position? Correct.
Right, okay,
Correct.
thank you.
All right, I guess I'll give you the last question. I understand all of what you're saying, and I think the premise of the bill is trying to give the patient the right to choose. Would you feel in your daily experience of talking with your customers, so to speak, that if you have the opportunity to have that discussion and explain the importance of it, would it be reasonable to think that most people are going to decide this is the right choice for me?
I've always found that, actually. I've probably had in maybe 10 years one patient where they said, okay, I'm going to leave the practice. Usually if this comes up, I usually go in and just sit with the patient, have the conversation as to what the importance is, and I'll show them pictures and diagrams and whatever we need to make sure we've educated them. And I don't have that issue, and I've been speaking with colleagues because we knew this bill was coming up. Similar situations of the colleagues I spoke with at the Dental Society. And we represent well over half, almost the majority of the dentists in the state at the New Hampshire Dental Society.
So I guess the harder question is, once you've had the conversation, excuse me, and in the case perhaps of the representative introduced, he still feels the best decision is not to have this. Do you feel it's the right of that person then to go choose another dentist, or
Yeah.
more than saying it's the right to force you to do something that you
Yep.
aren't comfortable with? as a
100%. 100%. I think a patient needs to develop that relationship with their doctor that they feel the confidence in. And if they don't feel the confidence in what they're saying, they should choose another practitioner.
So I guess if we pass this bill, it would allow the representative to then say, I'm going to go to another dentist who is comfortable doing this. But currently, at least from what I'm understanding, is a dentist able to do this in New Hampshire without taking x-rays if the dentist is comfortable? Or are there guidelines that are saying, no, the dentist has to do this, or you can't?
There are guidelines that say you cannot go beyond 18 months to 2 years. Most dentists will limit it at 18 months, but 2 years, yeah. So even if you pass the bill, it's not going to change the practice of dentistry.
I
I think it's going to make it
I'll
more
go
difficult
one
on
more,
patients.
just because I want to make sure I understand. So if we pass this and we allow it so that if a dentist is comfortable doing this without having x-rays, that would at least provide care to those patients, make it available that don't want to have the x-rays for whatever their reason is, if it's a whatever personal issue that they choose not to, wouldn't it be reasonable to think that it would be good to offer that option at least?
I think it's misleading because I think they're going to bounce around from dentist to dentist to dentist for years because I've never met a dentist that doesn't follow the standard of care. So I think it's misleading for a patient. I think it just creates frustration in their own lives. And then they go to the next dentist with the same problem.
Okay.
It's a tough one.
Well,
I feel for it. I really do. But I also don't want to be misleading to our,
Sure.
the people of New Hampshire.
Well, thanks for coming in today.
Absolutely.
One
Happy
more?
to.
What's the reimbursement on a set of x-rays, bite wings or full set?
Great question. I don't know the exact cost. A lot depends, on the fee schedule. Are we determining by insurance or non-insurance? But somewhere in the $100 range for a set of bite wings. 80 to 100, I would say.
And how does that equate to the percentage of reimbursement, the percentage of the whole visit? So you come in for regular cleaning, you do for x-rays, you have the x-rays. If you didn't have the x-rays, what would that,
Yeah.
What's the total visit cost, general, average reimbursement?
So I would say it's less than 30% of the cost of the visit. But if you're looking at 2 cleanings a year, now you're looking at less than 15% of the cost of your dental care for the year. I'd have to look at the numbers. Unfortunately, I don't really follow detailed numbers at my own practice. We just do what's necessary.
So if I follow you, 30%, so if you get $100 reimbursement for a set of x-rays, it's 300 reimbursement?
Yeah,
for the
because
whole-
you're doing
for
a
the whole
cleaning,
thing?
plus there might be fluoride. So if there's no fluoride, it might be less. I think every situation's different, but I'd be happy to get you those numbers to get some data on those.
Thank
I
you
think
so much.
if that's important to you, we'll get it for you.
Thanks.
Yeah.
All right, well, thanks for your testimony. We
Right.
appreciate it.
Thank you, everyone.
Joan Fitzgerald?
Good morning. Good morning, Senator Pearl and
Good
members of the committee. My name is Joan Fitzgerald. I am the advocacy chair for the New Hampshire Dental Hygienists Association. And I want to thank you for the opportunity for me to speak in opposition to House Bill 1286 on behalf of the New Hampshire Dental Hygienists Association. At its core, dental hygiene is about disease prevention, early detection, and patient education. Dental hygienists are often the first licensed healthcare professionals to assess a patient's oral health status. We are trained to identify the earliest signs of disease, often before the patient feels pain or sees a visible symptom. That preventive role is essential, not only to oral health, but to overall health. And radiographs are not optional in that process. They are critical. Much of the disease we are trained to detect exists below the surface where the eye cannot see, such as cavities between the teeth. With gum disease, there's bone loss, there's accretions that grow below the gum line that cannot be seen with the visible eye and can be detected on a radiograph. Again, it's after the fact. However, it's really vitally important in the diagnostic arena. Without radiographs, these conditions can and will be missed until they progress to more advanced, more harmful stages. This bill would fundamentally weaken the ability of dental hygienists to fulfill their role. In New Hampshire, dental hygienists are licensed professionals with a defined scope of practice that includes assessment, data collection, and collaboration in diagnosis and care planning. Radiographs are a cornerstone of that process. Without them, we are being asked to practice with incomplete and potentially misleading information, essentially working in the dark. House Bill 1286 shifts decision-making away from trained clinicians and toward patients who may not fully understand the clinical consequences of their decision. While patient autonomy is important, it's very important, it must be balanced with safe, evidence-based care. Allowing patients to decline necessary radiographs while still receiving treatment creates a dangerous gap between what is recommended and what is delivered. It also places dental hygienists and dentists in an ethical conflict. Expected to prevent disease and protect patients while being denied the very tools required to do so. This bill does not reduce risk, it increases it. It increases the risk of missed disease. It increases the risk of delayed diagnosis. Ultimately, it increases the risk of more invasive, more costly, and more traumatic care for patients. As preventive specialists, dental hygienists know that the most effective care is the care that happens before disease progresses. Radiographs are essential to understanding where the patient is at that time and place, and in making that prevention possible. For these reasons, we respectfully urge the committee to vote inexpedient to legislate on House Bill 1286. And I thank you for your time, and I'm open to any questions.
Well, thank you for your testimony. Senator McGill.
Thank you, Mr. Chairman. Thank you for bringing your expertise. I appreciate it. I guess my question is, you mentioned that the patient may not fully understand the consequences. My own dental practice, my hygienist, they come to every visit with an actual PowerPoint deck, and they display it on the TV, and then they put it in your lap. So I'm wondering if, is that not common to educate the patient as part of the visit on what those consequences would be of refusing or deferring fluoride, x-rays, having your opposing wisdom?
Yes, it's
tooth
a key.
taken?
It's a key portion of what we do. We educate the patient on what it takes to prevent the disease. Yes.
Follow up.
Got one more.
So, is it okay for a patient to defer, say, extraction of the opposing wisdom tooth if one's coming out because it had a disease process and the opposing one that you advise take it out? Is it okay for them to defer that, or to defer another extraction and a crown, but it's just not okay to defer?
Well, extractions are not in my scope of practice. That would be the scope of practice of the dentist, and I would certainly collaborate with the dentist to understand where that diagnostic choice comes from, but that needs to be deferred to the dentist.
Thank
All
you.
right, thank you. I'm going to move us along because we're running a little bit slow today. So thank you for your testimony.
Thank you.
Leslie Nixon. Good morning and welcome.
Good morning. Thank you. My name's Leslie Nixon, and I am from New Boston. I'm also a lawyer, and I just happened to, I had nothing to do with this bill being introduced, but I happened to, when looking at some other legislation, see that it had been introduced. And so I'm speaking today as a patient, because I have experienced the same kinds of frustrations that Representative Drago was talking about. And I've been lucky enough to be on this earth for almost 70 years at this point. I've had at least 5 different dentists that I can count. And the reason so many is because precisely of that reason. I've tried to find a dentist that would allow me to get my cleanings, but not require me to have x-rays. And they don't. I don't think there is a dentist in this state that will give you that choice. And I see this bill, obviously I'm here in support of it, as a matter of patient choice. I have never, to this date, I've had some dental issues, never one as a result that was diagnosed as a result of an X-ray. I've never had an X-ray that actually found anything. Now, that's anecdotal, true, but I will also tell you that coming from my legal background, I have had a couple of dental malpractice cases. I have represented patients who have had dental problems, and they are have been much more serious than simply missing a cavity because an X-ray wasn't done. And I'll say, Representative Reardon, in response to your or Senator Reardon, excuse me, in response to your question about whether this bill would give immunity, I think it's actually very narrowly written. It says that the patient, if the patient signs a waiver, he or she is only waiving the right to sue the dentist in the event that the lack of a radiographic examination results in unforeseen injury to the patient. So I see it's very limited. It's saying if you sign the waiver and something happens because you didn't have an X-ray, you can't sue because of that something that happened, whatever that may be. And I will tell you, frankly, there's no lawyer that I know that would take a case of a patient coming in and saying, oh, well, I signed a waiver and I didn't get an X-ray and now I have a cavity. So can I sue my dentist? That is not going to happen. There is no, and you know, I'm very familiar with standard of care and what that means in legal terms, both in the medical situation and in the dental situation. And it's not necessarily determined by what the ADA says. It's determined by what a reasonably competent dentist practicing dentistry would do. And it's ultimately a determination made by a jury. It's not, you know, just because the ADA says something, it doesn't necessarily mean that the jury is going to agree that what the ADA says is the standard of care. So I think this is a good bill. I think it gives, and someone asked about the average cost and so forth of an X-ray compared to a cleaning. It's dramatically higher, and it's not $100. It's much more than that. It's several $100s. When I come in and I want a cleaning and I don't want an X-ray, part of it's based on cost. Part of it's based on discomfort. I don't like having those things shoved in my mouth. But, you know, it's also just on principle. I don't know of any other medical diagnostic procedure that if a patient refuses it, their doctor is going to refuse to treat them. For example, if I go to my primary care physician and she says, well, you should get a mammogram. And I say, no, I'm not going to do that this year. I don't feel like I need one. You know, I'm not concerned. Cancer's not in my family history, etc. She's not going to say, all right, well, then I'm not going to treat you. This procedure, dental X-rays, are the only example that I know of where you can actually be refused treatment. And it's not just a personal issue. It's a serious consequence to the health of the population. Dental problems can lead to very, very serious consequences. But the majority of people who don't get good dental care do so because they can't afford it. And this makes it even more costly. Yes, everybody should be getting regular checkups and cleanings. But if I'm told that I'm going to have to pay $400 for an X-ray just to get my $100 cleaning, and I can't afford that, then I'm going to not do it. And that's what the choice is right now. And that's not a good choice. It's not a good choice for our citizens. they should be able to at least have the option of getting evaluated and getting the cleaning and then making their own decision. And I do think that anybody, if there is a real reason for an x-ray, a dentist or the hygienist says, you know, I see a spot on your teeth and I'm a little concerned about it, I think most people certainly would agree, yes, in that case, go ahead with the x-ray. But just to have it because, well, it's, you know, this is our practice, every 2 years we have to do it, doesn't make any sense to me, medically or otherwise. So I was concerned also by the testimony of the dentist on behalf of the Dental Society, who said, well, even if you pass this bill, nothing's going to change. That really concerns me. And that tells me that maybe you have to go further and say patients should have the right to say no. But thank you for your attention.
Thank you for your testimony.
Oh, I'm
Anybody else
sorry.
that would
I'll
like
take
to-
any questions.
Any questions? I think we're good. Thank you.
Yeah.
Anybody else wants to testify on 1286? All right, I'm going to close the hearing. Next, we will open up the hearing on House Bill 1312. Is Representative Leon still here? Huh? All right. Anybody here to introduce 1312? All right. I guess I will introduce it. We're going to open the hearing on House Bill 1312. This bill authorizes boards under the purview of the Office of Professional Licensure and Certification to establish subcommittees subject to rules established by the office. It also removes the authority of the Board of Registration and Optometry to modify the list of approved pharmaceuticals for use by optometrists. And lastly, it removes the authority of the Board of Accountancy to establish administrative fines by rule. And with that, I will, Steve, do you want to go first or do you want to wait a little bit? Okay, all right, Dee, I'm going to bring you up then. I'm going to bring up Dee Jurius, the Director of OPLC. I did. Yes.
That's what was happening.
That's okay. That was me.
Coming up for it too.
So Dee can talk about the bill as it is, plus she has brought in some language forward for an amendment that I believe, Ben, did that get distributed? I believe everybody has it, Amendment 1293S. So when you're talking about the bill, once you're done with that, if you want to talk about the amendment as well.
Absolutely. Do you have a copy of that printed amendment that I could reference? Thank you. So just for the record, Deanna Juris, Executive Director at OPLC. So on the underlying bill that was passed by the House, this is largely, certainly sections 2 and 3 are cleanup that was identified in the administrative rulemaking process. So we, as you know, we do about 25% of the state's rulemaking goes through the Joint Legislative Committee for Administrative Rules. And the attorneys there that do review often flag rules that maybe have existed, either statutes have changed, have been repealed, or the authority has changed. And so some of those came up as flagged. So one of those is the optometry. In connecting with the Optometry Association, I didn't give their full title right, but I'm sure their representative will make sure that that's good for the record. Had some concerns about section, so if we're on the bill on page 1, the letter I, line 21, kind of has a catch-all for pharmaceutical agents, solely diagnostic agents combined with pharmaceutical agents. So that kind of compounding catch-all, they were concerned about just leaving that extremely broad and wanted to say that there should be some way to maintain within that catch-all spectrum in rule or in the formulary that's there. So that was one concern. And then there were a few other strike-throughs that were missed. So that's in the underlying portion of the bill there. The other section around the board subcommittees. So their licensing boards have 2 primary responsibilities. So they set criteria in rule, and then they do findings of fact in determining sanctions and disciplinary proceedings. Sometimes the rules that they have to adopt, or there are some boards that write their own examinations. Sometimes the scope of that work is quite broad. And we wanted to establish kind of a clear procedure about what having a subcommittee, a smaller group of the board would be to conduct that work outside of the regular, often monthly board meeting. Now, the reason for allowing for some procedural rules here is that one can imagine with 58 different licensed professions under the office, if every board decided we need 3 subcommittees and they're all going to meet monthly, then I am almost infinitely, right, like the degree of magnitude of the number of board meetings that require support, that require notice of meeting, that require legal support is just way beyond the staffing. And so it's to be able to retain some ability to just determine time, place, and manner of those subcommittees. So it's not just a blanket, any board can notice a meeting at any time, because the office is obligated to provide that support. So that is the request there, is really just to allow the OPLC to do some rulemaking around that. Not to say that they can't have subcommittees, but to ensure that it's done formally and in a way that the office can provide that support. That's the underlying bill. Do you want to just move right into the amendment?
Sure. Why don't you discuss the changes that you are suggesting?
Absolutely, happy to do that. So within the amendment, the first section about the optometry cleanup. So the underlying bill proposed striking RSA 327:6A Roman 6, and then all of the references to it. In that section, there's there is language towards the bottom, so on the amendment line 27 of the first page. It uses the word approval, and as you've heard many times before, when I come before you, the word approval in 541A is part of the extremely broad definition of a license. I don't believe that the legislative intent is for that kind of licensing, so I kind of updated the language so that it didn't include that term and there was no confusion there. So it says the board shall have the authority to review and update the formulary for pharmaceutical agents as described in RSA 327(1)(3)I. So that was the section in the original bill. That was the concern of the association, for use by optometrists certified to use pharmaceutical agents in the practice of optometry. So it's still very limited. So it, instead of striking the entire thing, it updates it to just say include the formulary specific to that catch-all, and then includes the strike through of that section in the other definitions above on that page. So letters C, D, H. It strikes the approved language in I, but it leaves the formulary inclusion J, L, and M. I'm happy to kind of just pause there because there's kind of a lot of moving parts. Essentially, it's get rid of the approval language, allow the catch-all to be a formulary just specific for those pharmaceutical agents. Okay. The next proposal is in the Medical Imaging and Radiation Therapy Rulemaking Authority. So that's section 5 of the bill, beginning on line 10 of page 2. So this is the exact same thing I was talking about with the approval language. What we had seen was there's a repeal at the end of the bill. I apologize. 328J8. And because that language specified that it contemplated that the office with the advisory board approved these programs for medical imaging and radiation therapy. I don't think, and the committee certainly could correct me if I'm wrong, but my understanding of the legislative intent of that was not to say that these schools that are providing this medical imaging, the radiation technology, that they would have to get a credential and renew it with the office every 2 years, paying a licensing fee, applying to be a school. I don't think that was the intent. I think the intent was to say the board should set some standards that these schools have to abide by law, but that when they graduate. So what I did was retain the standards in the rulemaking authority. So instead of standards for educational program approval, which again contemplates the granting of a credential by the office, So it says standards for educational programs, which shall be no less stringent than the standards approved by, and then it names the three entities that are already named in law in the other section that is struck. So it maintains the criteria, but removes the contemplation of a credential for that program and just allows rulemaking to say, hey, schools, if you're doing this, here's the standards you have to follow, but that you don't have to apply for a credential and pay a fee from the state.
Okay.
Okay. And then the last section is relates to the family mediators. So we had, I had gotten some feedback from our office that there was some challenge with this board getting members on and meeting quorum. And the primary challenge is that in letter D, so line 21 on page 2, that this board was made up of 3 certified family mediators who were nominated by the New Hampshire Conflict Resolution Association. So there was a private organization that had to make the nomination for the governor and council to act on. It's my understanding that that association is not currently operating. And so there was they were kind of stuck where there was no nomination to kick off the process. And that was really the critical reason to take a look at this statute to say, okay, let's bring this more in line with most of the other boards to say it's the governor and the consent of the council. Certainly any association could weigh in after a nomination is made in that process, as it does with the vast majority of the other boards within the office. While we were there, I asked the attorney that works with the Family Mediators Board to look at other potential structural changes that are making it difficult for the board to meet, or other cleanup that we've missed along the way coming into line with the changes this legislature has made in 310, which is the governing statute of the office. So just working my way right down, the first change is to define office or OPLC in that specific statute for clarity, to strike the reference to that association making the nomination. Down at line 24, to strike the specific months in which the board may meet and leave it more open-ended. We did retain that in January they have to establish the time of day and day of the month for regular meetings. That is the standard practice of the office, so it's not disruptive. It is quite prescriptive, but that is currently our practice, is to publish dates for the entire year. To strike letter B, it's not needed in this statute that determining time, place, and manner of a board meeting is the office's function, and certainly it can be rescheduled. Again, it was just very prescriptive in the statute. Some minor adjustments to the definition of quorum. That's one of those things we're always kind of on the lookout for when things get interesting or there's something specific, to just say it's a majority of the members currently serving. So if you have 3 members of a board, 2 could conduct a business if there's only 3 appointed members, whereas right now, if you only have 3 members, all of them have to be there to conduct any business. And then towards the end here, updating, as you know, I think every session you see, we're changing things that don't say 2 years for any license duration to say 2 years so that it falls in line with 310 and cleans it up there. There are 2 references here to 310.8 under the licensing section, so lines 34 and 36. Existing certification shall not expire until it just says office, because the office is the one who's granting the credential based on criteria set by the board. It uses the correct term expire instead of lapse based on the definitions in 310. Then the last 2, again, office or board in line 7. And then the continuing education, so it's within 2 years because that's the new renewal cycle. So then it does the math, right? If it was 3 and 24, it's 2 and 16.
All right.
So it's a lot, but really very ticky-tack cleanup. And said, while we have it open to try to renew that nomination, we could do some of this other cleanup.
So just for the benefit of the committee, I'm not going to try and exec this week. I want you to have a little chance to digest this. So I would say if you have questions on any of those technical aspects, you could certainly ask now, or feel free to reach out to the director as we go through the next week. Go ahead,
Just one
Senator
question.
Also.
Thank you. Thank you, Mr. Chair. Thank you for taking my question. Could you go back to page 2
Of the amendment?
Of the amendment, yeah.
Yes.
Oh, that's what we're talking about, right? Yeah, the amendment. Page 2 of the amendment. And you're going over lines 12 through 16, so part 12. Programs which shall be no less stringent than standards approved by the so what are we doing here? Like, can you explain that one more
I'm
time?
happy to.
I got a little lost in those details. If you could just walk me through it one more time.
I'm happy to do
Yeah,
that.
thank you.
So what when we draft a bill, obviously for consideration, we don't have the whole statute, and in some ways it would be helpful, and in other ways it would be way too many pages. So I'm going to jump to a different section, but it relates directly to that. So on line 19 of page 3, Roman 2 there, it proposes to repeal 328J8 relative to medical imaging and radiation therapy educational programs. So that statute, I copied and pasted that section into the rulemaking section because that line, I don't have it in front of me, but it essentially just said, the office shall approve programs which shall be no less stringent than blank, 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 blank. So I brought that language. I didn't change that standard that was in statute. I just allowed it to be in rulemaking for criteria without an approval of the office for that program. So I maintain what was in statute. So because I really do want to be mindful of certainly telling you if I'm recommending a policy change, but really I think this is coming in line with the legislative intent, which is we want there to be some level of criteria in law, but we don't need you to fill out a bunch of forms and pay every 2 years to continue to provide that education. And so I didn't change the policy decision of naming those 3 entities. I just moved them to the rulemaking section.
Okay. May I follow up?
Sure.
Okay, I'm with you so far. Can you go back to say we don't want you to have to fill out all kinds of paperwork every 2 years, but how often are the standards reviewed if it's not every 2 years?
Okay, yes. When I'm talking about every 2 years, I'm applying to the duration of any credential that is issued by the office except for the apprentice. So the reality is that these programs have to maintain their if it's part of a post-secondary school, which the programs in New Hampshire are, they have their accreditations within their larger institution, and then they might have certifications here. So that is the oversight, I guess, is outside of the OPLC. Though it's not an additional credential that my office grants, that it says you need to meet these criteria.
We're leaning on the professional orgs. Thank you. All right. There you go.
Yes.
Bling.
Yes.
Cleared up.
Senator McHugh?
Thank you, Mr. Chairman. Thank you, Director Jurius, for taking my question and lending your technical expertise. I'm trying to understand if we delete all of the lines that say approved pursuant to RSA 327-6A Roman 6, does that expand, or does that expand the list of pharmaceutical agents that can be given, or somehow make it easier? Why do we need to remove all those approvals references?
I think the reality is that this is slightly outside of my regulatory expertise and more into the practice, and I do think there's someone with the more expertise in the field that can speak to this. But it's my understanding that the list where it is struck, so meiotic agents, antibiotics, some of them don't have that approval, right? The anti-allergy, that those they're widely accepted. We don't need to have a list of them that it's approved. It's a part of the standard of practice. It's unobjectionable largely within the community. And so my understanding is that approval process just creates a greater potential barrier. If there was something else that came on the market that fit within this categories, that you're not waiting on the board to provide that update, that it would allow. So that's my general understanding. And like I said, the initial the ask of the underlying bill was to just remove the entire thing. So what we've kind of done is come a little bit in between to say within that catch-all, it's not just a blank approval. Any of these things can be included, that there is some oversight in that compounding catch-all in Roman I. But I think I'd defer the technical practice piece for the approval to folks behind me that can speak more clearly in the profession.
One more, and then I'm gonna move us along.
Okay,
I'm gonna give you time to ask, outside if you want to.
Yeah, I can do that. But Roman I, you mean 327-1, section Roman 3, small I, in line 29? I couldn't find it. I just couldn't find, I wonder if it's a.
That
direct
is line 17 of the bill, of the amendment, the proposed amendment. So that reference 327-1, 3 little I is line 17 through 19 of the bill.
Of
the amendment, excuse me, the amendment.
It's new. Oh, yes, I see. Okay. All right. That's why I couldn't find it.
Thank you.
Thanks. Sorry.
All right. Thank you, Director. I'm certain there may be more questions.
Thank you.
Steve? Good morning and welcome.
Good morning, Mr. Chairman, committee members. I know you're running behind, so I'll do my best to keep it moving for you. I appreciate taking a moment to hear our testimony. I'm testifying on behalf of the original bill that was introduced today, not the amendment. I would reserve any further comments after review of the amendment, if possible, if necessary. My concern is at the very top half of the bill, where it talks about the subcommittees for the boards.
Just FYI, that is the same in the amendment. It didn't change.
That didn't change, okay. There was a lot going on there.
Yes,
so.
I know.
The fact that you keep track of it was pretty good. So we have a concern that with this, originally the idea of allowing boards to have subcommittees is not new. We've had them before. We've had them for many years. I'm also here representing the ECBA, Electrical Contractors Business Association. I'm a licensed electrician. Last year, we put into the law to our RSA for a subcommittee, because when we went to try to get one, we were told it's not in our law. You have to have it in law. So we put it in, and this year is the first time the subcommittee, it was based on this one, that this was brought forward. We have a subcommittee that reviews the testing questions for our licensees. As the code changes every 3 years, once it's currently adopted by the state, the testing questions change. The students are in school for 4 years. They anticipate their timing of it, knowing that, okay, I'm a third-year apprentice going to school. I'm going to be testing on the 2023 code, not the 2020. So this committee was formed. I've been a part of it for many years. They get together, they go over all the testing questions, make sure that they're relevant to the code, the local adopted code, because you might talk about arc faults and it's different in 23 code than it is in the 20 code. It's a technical thing that would bore you to death. We spent 2 days doing it. It was a large committee, excuse me, and we all had to sign NDAs with the testing facility so we couldn't discuss it. So it's up until last year, we put that in to allow us to do it, passed legislation in RSA 319C4. Most of these boards are volunteer boards. We don't look to increase the cost to the state, to OPLC, to every licensee for a subcommittee. They get together, they find a place to get together, they confer, get the information, and then there's usually one board member involved, and they bring that back to the board. RSA 319C4, and I can have you make copies if you want, but and it says it in this one as well, if I look back, it says, for the purpose, page 1, line 3, it says, with the approval of the executive director. We would like that to say with the approval of the board, and I can explain further why. Any board may be established a subcommittee or subcommittees for the purpose of reviewing and making recommendations on matters which can be handled by the full board. The whole point of that's the wording that was put into our RSA. We agreed to have it be the executive director as a compromise. We didn't really want that. And we're looking to get that changed. That was all that was in there. The rest of it is additional from what we put it, time, place, and all that. So we have a situation now where we have students that were taught to be ready to test for the 23 code. And right now, because this has been delayed in such a long process, they're going to have to test on the 2020. So you're talking about stopping people from getting their licenses, progression, and professionalism because of it. It's a very important one, this particular committee. So we think that it's become too convoluted. There's the technical expertise of the boards, it ranges anywhere from 60 to 100 years in professional experience. And it's very hard for them to understand what an arc fault is, what a ground fault is, if it should be this or that, if it applies to the code, not to bore you. The board's institutional knowledge is taken, and so any process or any concern about following procedure, public hearings, public notification, all that is all done with the board meeting. The information is gathered from the subcommittee, it goes to the board and goes through all of that. So there's no reason to do it as a full board position. As one of the members that was elected, so to speak, to be on this board, I got a 19-page form as if I'm going to actually be on the board, I-9, a social security card, everything that I need to do in case I get a stipend. I'm not looking to get paid. Most of the people aren't. We're just trying to help and volunteer for the state. So it's usually they gather all the information, they bring it to the board takes it from there and considers on. No decisions or rulemaking or procedures or changes without going through the board. It has its checks and balances. It's bogged down the system in the fact that this should have happened 6 months ago so that we were prepared, because in January, the new code became in effect. So we just think that this is going to cause an issue with more boards going forward. We'd like to see the wording changed to allow the board to determine when they need it, if they need it, and not get it tied into all of this. I have more, but I will let you ask questions if that's.
Thank you. Well, Steve, I think you heard testimony from the commissioner, and I know I've got some notes from the House as well, that their concern is about related to the support staff that has to be provided for your subcommittee meetings. And I think this was their attempt at making something that could be manageable by OPLC, because there's 58 boards, I think, if I remember right, under their purview that potentially could all be calling multiple subcommittee meetings. So I understand your concern, and what I'll say to you is I'll have a further conversation with the director and see if we can figure out a way to try and, I guess, is this, I'm going to ask the director a question while you're sitting there. She can give me a thumbs up or down. Is this in conflict with what we passed with the electricians board last year about their subcommittees?
As proposed?
Yes.
Would pose no conflict.
Okay.
It wouldn't change anything about what's in existence.
All right. Let's have a further conversation on it, okay? Because we are running a little tight today.
Because the second half of that part is not there. I do have a copy of 319C.
All
And
right.
also, this would take care of that burden because they wouldn't have to do all this. They can barely keep up now. So that's,
I'm going to make a note. We'll have a conversation about it.
okay. Thank you.
Thank you. Any further questions from the committee? All right, seeing none, thank you. Anybody else wants to testify on 1312?
I'm happy to answer questions now or offline.
If you've got something quick you think the board needs, we've got a couple of minutes.
We can do it offline.
Okay.
Easy answers.
All right. Perfect, thank you. With that, we'll close the hearing on 1312. Next, we'll open up the hearing on House Bill 1407. What's that?
You know why we're running behind?
Yes.
Because the clock is over there.
I know. Representative Long, are you here to introduce?
It's true. It's true. I wish it would happen.
We're right there.
See you.
All right, sir, you have the floor.
Good morning again, Mr. Chair, members of the committee. This one I actually was planning on speaking on. This is a simple bill to allow veterinary technicians to give rabies shots while indirectly supervised by a veterinarian. And I want to emphasize that indirect supervision does not mean no supervision. It means the vet has examined the animal and has given instructions for treatment. This allows the vet to focus on more complex issues at the top of their license while the technician handles this routine vaccination. There's no need for a veterinary license just to administer a vaccine. If you compare that to the situation with humans, we allow nurses, physician's assistants, pharmacy technicians, pharmacy interns, all kinds of people other than just doctors and pharmacists to administer the vaccines. Several other states allow veterinary technicians to give rabies under indirect supervision, including California, which has way more people, way more pets than New Hampshire. They haven't had any problems as a result of allowing this. I think Maine is also one of the other ones that allows it. So this would save consumers money and time. They no longer need to pay for the vet's time or wait for the vet's availability for a service that can be done by a technician. And I know the biggest question that came up in the House with this bill was around the definition of a veterinary technician, because it's not defined in this bill, but it is defined in current regulations. So I don't think, and ultimately the House didn't think, that it was necessary to define it in this bill because it's already something that is handled by regulations. So that there is a restriction and the vet can't just have some random person giving the vaccine.
Thank you for your testimony. Questions from the committee? Seeing none?
All right.
Kurt?
Thank you.
Good morning, welcome.
Good morning. Kurt Ehrenberg for Humane World for Animals. I'm the New Hampshire State Director. I appreciate your allowing me to speak today. On behalf of our New Hampshire supporters, Humane World for Animals, we strongly support House Bill 1407. This bill authorizes veterinary technicians to administer rabies vaccinations under the indirect supervision of a licensed veterinarian. Currently, only veterinarians are permitted to give rabies vaccines. Allowing veterinary technicians to administer rabies vaccines is important because it will increase access to essential preventative veterinary care and potentially reduce costs. As is the case all over the country, lack of access to veterinary care and rapid rising costs for veterinary care are a crisis in our state. Veterinary technicians, as defined by New Hampshire Administrative Code, are highly trained professionals who have graduated from accredited programs, passed the national VTNE exam, and are credentialed. They are qualified to safely provide rabies vaccinations. Allowing technicians to give rabies vaccinations will free up veterinarians to focus on essential services only they can provide. It can also support community vaccine clinics, expand appointment availability, and reduce wait times and costs. Rabies is a deadly disease for people and animals. It is a threat to public health. Vaccination is the most effective public health tool to prevent rabies, and that is why vaccination is required by law for dogs, cats, and ferrets. These pets are required to receive their first rabies vaccine at 3 months of age, again at 9 to 12 months after the initial vaccination, and then receive boosters at regular 1 or 3 year intervals for the rest of their lives. That's the law. These are important routine preventative services. Again, they are legally mandated even though many people face significant barriers accessing the service, including cost, transportation, availability of appointments, and more. Rabies prevention is essential, but is out of reach for many families in New Hampshire. House Bill 1407 simply improves access and lowers costs. We estimate that at a minimum, 55,862 pets are living with their families, experiencing poverty across New Hampshire. Additionally, an estimated almost 200,000 pets are living with families considered asset limited and income constrained, but employed. This threshold measures families above the poverty line but still struggling to, where are we? Sorry, struggling to meet basic needs like housing, food, and childcare. Many of these families with pets who could benefit greatly from increased access to veterinary care and more affordable rabies vaccinations. And I'm almost done. But this is really important for the animals in the state and the people who own them, particularly lower income people who cannot comply with the law because of their circumstances. This would help them enormously comply with our laws, be much better pet owners, and maintain a healthy pet that is not a threat to their neighbors. And I'll leave it at that, and I'll take any questions.
Thank you for your testimony. I guess the first one that comes to my mind is, are we requiring any oversight by a licensed veterinarian in the?
Absolutely, it's indirect supervision means supervision, and it just means that the vet doesn't have to be in the room.
So that, in your opinion, then this bill would still require the veterinary to be reviewing the
Absolutely,
records and
the
making
vet is involved
Yeah,
from beginning to end. It doesn't change any of that. It just simply allows the shot to be given by a trained professional.
And one more follow-up, and then I'm gonna go to the two. So a veterinary tech has to work under the practice of a veterinarian. So I guess I'm curious how that's gonna save the constituent money or the customer money, because they're still gonna have to be at the same practice. I'd just like you to elaborate on that.
Well, it's just the volume. I mean, it's common sense. Just,
Okay.
I don't think I have to explain it more than that.
Senator McGee?
Thank you, Mr. Chairman. Thank you for taking my question. We have rabies clinics in our town all the time. And I'm wondering, could a vet tech go to the ambulance garage where they're traditionally held?
Under the supervision
Well,
of
could the vet tech go there without the veterinarian? Like, so the veterinarian could have his Saturday and they could send a vet tech to do it.
I would hope they could.
Is that still indirect
I
supervision? I'm not
I believe it is, and I think it's important for access that these trained clinicians can administer a shot under the supervision of a licensed veterinarian who's responsible for the outcome. I see no problem with that. These vet techs administer all kinds of other treatments to their patients.
Senator also.
Thank you, Mr. Chair. Thank you very much. So would you believe I bumped up against this myself for the very first time in all my years of having dogs. My dog gets, because she's elderly, gets allergy shots, which I gotta, otherwise it's just painful for all of us. But I gotta run her to the vet every 6 weeks for an allergy shot, which is administered by a vet tech. We go in, we sit in the room, the vet tech comes in, does the little, checkup, and then goes and consults with the vet, comes back in, we get the shot, we're out the door. And knowing that we were going to be in on Monday, which was also my dentist day, we do all the things on Mondays. Knowing I was going to be going in on Monday, and my dog is going to have to be updated on her rabies shot at the end of April. I asked, well, can we do the rabies shot at the same time? Because I'm going to be there. We got to get the, if there's no contraindications, can I do both? And they said, oh, no, actually, because you have an appointment with a vet tech for the allergy shot. And I'm like, okay, heard. I want to do another shot. And they're like, yeah, no, the veterinarian has to do the rabies shot. And
of course, it would be up to the veterinarian whether to allow you to have your pet vaccinated by a vet tech. It's not mandated in any way. It's just allowed.
With this bill, it would be allowed.
Correct.
But under current statute, they have to be the ones doing the administering, and she did not have any appointments or time to be able to do that on Monday. So I'm now going back at the end of the month and going to have to pay for a second visit with the vet, who is a little more expensive than the vet tech. And now that's 2 times for what could have been done in the 15-minute appointment that we had on Monday. So I thank you for supporting this.
Well, thank you. And I'm not a veterinarian, so, I mean, I can't say, but it's important to consider, and when you hear that there's a little bit of a difference to the rabies shot, it's more serious, it's a more serious condition, rabies. Well, that's true. As I said, and as is factual, rabies is deadly. And because of the barriers that we currently have to more and easier access to the rabies vaccine, it endangers our community. So this is a really good bill. I hope you vote out to pass when the time comes. Thank you.
Thank you for your testimony. Elizabeth Rapp, maybe? Rupp? Might be Rupp. Is Elizabeth here?
She might have signed up on the wrong page.
Okay. All right. Jane Barlow. Good morning and welcome.
Good morning. Thank you very much for having me here today. My name is Dr. Jane Barlow Roy. I am a practicing veterinarian here in the Concord area. I have been a practicing veterinarian for 20 years. I've also worked in at least a half dozen other practices, so I'm not speaking on just the practice that I work at currently, but other practices that I have participated in. I'm also representing the New Hampshire Veterinary Medical Association, and we are in opposition to this bill. I won't go into the details that have already been presented. Rabies is a 100% fatal disease. We do not have treatments in both humans and in dogs and cats. So this is a very important bill to us. And I guess I will just directly speak to what the definition of indirect supervision actually is. So I apologize, I'm going to read directly from what the law states it is. Indirect supervision means supervision where the supervising veterinarian is not required to be in the same facility or in close proximity to the individual being supervised, but the supervising veterinarian, 1, has given oral or written instructions for treatment of the animal patients involved, 2, is available to provide supervision by electronic and telephonic means, and has arranged for telephonic consultation with a licensed veterinarian if necessary. So basically what this bill is doing is it is skipping the in-between steps. So immediate supervision and direct supervision. So this means that a rabies vaccine can be given by a veterinary technician not in the same building. And we have serious concerns over this because we are not licensing veterinary technicians in RSA. So this means that the veterinarian is giving away their authority to a veterinary technician not even being in the building. So technically what that means is at these rabies clinics, which has already been talked about, we cannot send a veterinary technician out to do those clinics. So this means that we have very, very big reservations over this indirect supervision because they're not in our hospital. There have been instances where things have been given by a technician with a veterinarian in the building, but those levels of authority are very much with the individual veterinarian themselves, what they have comfort level with their technicians, comfort level with their staff. And so by relinquishing that authority, they're putting their license on the line. And I would definitely be hard pressed to find a veterinarian here in the state that would be willing to relinquish something so serious as the rabies vaccine to a technician to be done off their premises. To talk about the other things that are done in veterinary clinics, as long as I'm in the building, I am comfortable with my technicians giving that authority. If I'm not in the building, my technicians can do nothing but nail trims, nothing, because that is my license on the line. Other veterinarians may think differently, but I would be definitely hard pressed to find a veterinarian that would be willing to relinquish their license, for those purposes. I do find that this would be a very, very, very limited time this bill would be useful. It's not going to save the consumer the money that they think it's going to save. Just quickly, while I was in the gallery, I pulled up my phone, went on Google, and I searched for veterinary rabies vaccine clinics in New Hampshire in this month. And at least a half dozen came up just like that. Like you said, we do have a lot of vaccine clinics that are given at Tractor Supply, at the local shelters. I, in fact, am participating in one as a veterinarian at Pope Memorial on the 18th. These are low-cost vaccine clinics that are given by these facilities, in addition to the rabies clinics that are given, by the local towns at fire stations and places like that. So the access to care, in my opinion, is a moot point. We've been doing it this way for years. If you don't want to go to your veterinarian and have a physical exam, pay that money. I am 100% sure that you could find something in the next 2 weeks to get a rabies vaccine done, especially in the month of April when licenses are going to be due at the end of the month. It's not a hardship. I could go on, but in the interest of time, I'll end it there and let you guys ask any questions that you have of me.
Well, thank you for your testimony. Do we have questions? All right, I'll let him go first. Senator McGee.
Thank you, Doctor, for providing that testimony, and thank you for taking my question. Is there anything in the bill that would force you to allow your vet techs to do it? So if you didn't want to have your vet techs perform this under your license, you wouldn't have to. But like you said, some others may want to.
Correct. And the problem that I see isn't necessarily in veterinary clinics right now. Veterinary clinics are running under that operation. I see it being misused in other ways. In areas that you may have a veterinarian on record, in some of these facilities that don't necessarily operate as a clinic or a hospital. That is where I see maybe this becoming an area for fraudulency.
Thank you.
Senator Altshuler.
Thank you, Mr. Chair. Thank you for taking my question. So I would never presume that my own experience is the experience of everyone else, nor should it be used as a reason to create a law or not create a law. But I will lean on my own experience in this particular moment. So as I had said with the last person testifying, I just couldn't get both. I couldn't get the allergy shot, the Cytopoint injection, and the rabies shot in the same visit because I have to have the vet do it. So now I got to go back twice in the same month. I have the resources to do that because Mondays are my day. So she's going to go back on 2 Mondays from now. Would it be more palatable for you to narrow this to having it be on site so that, like you said, if you're not in the building, there are things that your vet techs cannot do. But if you are in the building, they still can't give a rabies shot. Would that, if you are on site, if veterinarians are on site for on-site supervision, if we made that change, would that make this a little more palatable?
I think
give less
yes.
heartburn?
I think that there would be an area to address those concerns because I know it was brought up in the work session that one of the representatives, I believe his daughter was a veterinarian, and they're like, oh yeah, this is already happening. And I can't speak for all veterinary clinics that are out there. It may be happening at other places where they are, hey, let me just run your pet back. We'll give the rabies shot real quick, and they'll go back. And so there may be a space where, we could be amenable to a direct supervision clause, and direct supervision is also defined, in law as well. And I think that would be something that, maybe on a conditional basis that we could see, if we could do this by somebody else's hand, one of your vet techs, we would be amenable to that. I think this is something that we have been, throwing around for a very long time. And I know that I've spoken to a couple of groups already this past summer, actually. And we just came to the conclusion that the language has to be very specific. Because of the huge public health implications that are revolving around the rabies vaccine, animals needing the rabies vaccine, we were very hesitant to change the law at that time and the RSA at that time because we couldn't agree on what was appropriate language that everybody would know crystal clear, black and white. At the current moment, the law is crystal clear, black and white. The vaccine has to be given by a veterinarian. And that's, I think, where the VMA has a hard time is once you start getting away from that language where it has to be from a veterinarian's hand, you'll start to get that drift. And when we start drifting away from the laws like this, I would hate to know that veterinarians are going to be a point of a rabies outbreak. I would hate to have that be, this is where the source of the problem is coming from because we're not, it's drifting from the original bill, or original RSA, excuse me.
You said it's a definition for direct supervision. Do you know what that is? Off the top of your head?
I don't. I could look it up. I don't have any of my so.
Do you has it? All right. I think we can find it.
Yeah.
Thank you. Did you have a further question? I'm sorry.
Just to follow up, so to make sure that there isn't that drift and that public health implications of rabies is contained and directly handled within the scope of veterinary practice. If it's within the veterinary practice and the vet tech is supervised within the veterinary practice, this isn't off-site, this isn't at other clinics, this is within the scope of your practice. Having a vet tech being able to administer that shot within the scope of the building, if you will, is that palatable?
It gets...
Or they have the choice.
There's not every veterinary practice works within a brick and mortar. There are offshoots that do mobile clinics, and they will send their technicians out to administer an antibiotic XYZ treatment. And so that's where I think the waters start to get muddy because not every veterinary practice is a brick and mortar. And so when we start to use language like that, again, the zone starts to get gray again. So there's, like I said, I have put this over in my brain several times before, and that's why we didn't introduce any sort of legislation, because the more you start to talk about what the rules should be and what those definitions should be, it's like, well, what if this? What if that? What if you start doing house calls? What if so there's a lot of unintended consequences that might show up, when we start kind of, again, veering away from the veterinarian, direct from my hand, to the pet.
Okay, thank you.
That's it?
Yep.
All right. Thank you for your testimony.
Thank you very much.
Anybody else? All right, I'm gonna close the hearing on House Bill 1407. And we will open the hearing on House Bill 1544. Anybody here to introduce? Is Representative Seaworth here still? Oh, there he is, sorry.
Wait. Did that not?
We'll get it.
Oh, okay. Yeah, does she have it? Like.
Good morning, sir, and welcome. Sorry, there was too much commotion here. I didn't pick you up.
Good morning. Thank you, Mr. Chairman. Thank you to the committee for having me this morning. I am Brian Seaworth. I represent the town of Pembroke, and I'm a co-sponsor on this bill. This is a bill that would direct the state to use fragrance-free products in its facilities that are frequented by the general public. Now, before I get started, let me apologize for bringing the second string in here this morning. The bill's prime sponsor was unfortunately called away on business travel and so was unable to be here. I will try my best to do him justice and you justice. Over the years, I've talked with the sponsor, Representative Proud, about these issues. For myself, I do go out of my way to use fragrance-free soaps and detergents and things for sensitive skin. Fortunately, in my own experience, the worst that's ever happened to me is if I use the wrong soap, I get a little bit of a rash or some irritation. But we do need to recognize that there are members of our community for whom this is a serious medical issue. It rises to the level of, for other people, a bee sting or a peanut allergy. So in many ways, what this bill does at the state level is fills in some gaps in federal law. So for example, if this were an employee issue, the Americans with Disability Act provides remedies that would solve it. But when you talk about the general public and state facilities, people don't have a continuous interaction. Some people go to the DMV once or twice a decade. They need to go up to the Secretary of State's office. They might do it once in a lifetime. And in situations like that, there isn't necessarily an ability to anticipate and seek accommodations if you have a medical issue. I did hand out a document. This is from the American Medical Association. It's a policy that they created last year on this very issue, recommending fragrance-free products within medical facilities and government agencies. Again, one way to look at this bill is it's just a way to close the gap and implement what that body has recommended. I do want to point out that this bill is not a mandate on local governments. It does not affect private enterprise in any way. It is restricted simply to state facilities and only those facilities that are open for use by the public. More good news, before filing this language, the prime sponsor spoke with Commissioner Arlinghouse, and we were assured that in terms of cost, this bill is at a minimum. The products that would need to be substituted perhaps under this bill are available from the same suppliers that we use today, and they're available at a very similar cost. Furthermore, the commissioner explained to us that the administrative costs of handling any kind of switchover would also be at a minimum. So members of the committee, I would just last of all point out that this is a bill that passed the House on the consent calendar. I hope that you will look favorably on its language and recommend it on to pass. I thank you for your time. I'm happy to take questions, but if you manage to stump me, I will certainly send it to the prime sponsor and have him get you whatever information you need.
Thank you for your testimony. Any questions? Senator Reardon?
Thank you, Mr. Chair. Are other states doing this? Is it typical in other states?
So there's exactly, and let me just make sure he didn't give me anything, the kind of question I would have to go back to the prime sponsor. We did not discuss implementation in other states. It does seem like it's something that's kind of picking up visibility now, so not sure. Thank you.
Further questions? All right, seeing none.
Thank you very much.
Anybody else that wants to testify on 1544? Seeing none, we'll close the hearing. And we got one left. We will open the hearing on House Bill 1727. Do we have anyone to introduce? I do not see anyone. You want to introduce?
Sure.
Go ahead. You can do it from here, I don't care. Representative McHugh is recognized to introduce the bill.
Thank you, Mr. Chairman. Here to introduce House Bill 1727 relative to interagency data sharing for the purposes of distributing summer electronic benefit transfers. In a nutshell, this bill will help feed 4,000 or 5,000 children over the summer. These are children who have already opted in to the free and reduced lunch, SNAP EBT program, but because the data, their address data, isn't shared because it's not allowed to be shared by the DOE, then it's difficult to deliver those benefits to those children once school gets out. This corrects that problem.
Thank you. Thank you, Senator. All right, Laura Milliken. I appreciate everybody's patience. I know we're running a little long today.
Thank you so much, Senator Pearl and members of the committee. I am Laura Milliken. I'm the Executive Director of New Hampshire Hunger Solutions. And as Senator McHugh said, this bill is intended to fill a gap that is happening where, so most kids who are known to the Department of Health and Human Services because they're on Medicaid or SNAP or TANF are directly certified for summer EBT, and they get sent a card in the mail, or their card that they got last year is activated. But there's this group of kids who's on free and reduced but is not known to the department, who are falling through the gaps. And the Department of Health and Human Services has really tried to create this address portal. I don't have the data from 2025, but in 2024, there were quite a number of children who did not, who's only about 60 families were successful at using the portal because there's no outreach. New Hampshire Hunger Solutions does the best it can on our social media, getting the word out. The DOE sent stuff to schools, but schools are out in the summer and parents aren't paying quite as much attention. We know that when school lets out, the safety net of school breakfast and lunch disappears. So summer EBT is intended to fill that gap. It's a small benefit. So we thought that this bill would be able to bridge the gap because that the addresses weren't getting to DOE. But as I understand from my colleague at DOE who can testify, there isn't a mechanism for even sharing the addresses. All the DOE gets is the state identified student ID numbers. So I met with my colleagues from DHHS and DOE in the hallway, and we weren't immediately able to come up with a solution. And so I wonder if the committee would consider creating a study commission for this. Because in addition to this small group of kids in summer EBT, the number of kids who are eligible but don't participate in summer feeding programs, which are the site-based feeding programs, is low. So relative to the kids in free and reduced, only about 19.4% of kids in 2024 were participating in those summer meal programs. So I think there's a problem of summer hunger that we're not meeting in the state. And so, to give us a little more time to figure out how we might address that, I think a study commission would be warranted.
Well, thank you. We don't have to hurry on this. If you feel like there's an opportunity where perhaps, and I'll throw this out because I see we have two other folks that are going to testify, if you feel there's an opportunity over the next 3 or 4 weeks that we could have conversations and perhaps come up with an answer, we don't have to hurry with this bill. Just I'll offer that as well.
Thank you. Thank you.
Study committees can be cumbersome at times, and I'm not certain that this would necessarily need one because you know who the stakeholders already are.
Mm-hmm.
So conversations can happen without necessarily.
Okay, well, we'll
a
certainly
study.
try to make that happen. I
But
appreciate that, Senator.
Just FYI, we have a little ability to move.
Thank you.
Senator, you had a question?
Thank you, Mr. Chairman. Thank you for taking my question. Would the language as originally introduced in the House be a better fix?
Apparently not. So I will So my colleague from the DOE can explain that better than I can. I was under the mistaken assumption that there was a file that was shared that simply didn't have the addresses, but apparently it's only the state identified student ID numbers that are shared, and so that doesn't solve the problem. So I think that there is a I mean, the issue of summer hunger is a really, really big one. Students have a hard time being ready for school when they're hungry in the summer. So I'll
Further
just
question?
Thank you.
put that out there.
All right, seeing none, thank you.
Thank you so much.
Melissa White? Good morning, welcome.
Good
It is still
morning.
morning, we got 20 more
Is it?
minutes.
Oh, yeah, there we go. Melissa White, Division Director for Learner Support, Department of Education. Thank you. I'm really here just to answer questions, but just to reiterate, we do not collect addresses at the Department of Education. Not only do we have an RSA that prevents us from collecting addresses and that type of identifying information, but we also do not collect it in any forms and any data collection from schools. So we have no way to share information because we don't collect it.
So this would be more of a DHHS issue than a Department of Ed, because I'll ask them, maybe they have the addresses. Is that where the information lies? So if you, why don't you come up?
Yeah,
too?
take it.
We'll have a conversation with both of you. This is Brian Clark.
Hello, I'm Brian Clark. I'm General Counsel for the Division of Economic Stability at the Department of Health and Human Services.
So I guess the question is, does anybody have these addresses? Somebody must someplace.
So on the free and reduced application form where the students qualify, the families do fill out that application that does have their address. That stays at the local level. We don't collect that information. They don't enter it into any system that we have. It's verified. And then in monitoring, we will go in and review, but we don't verify addresses or anything like that. We don't collect the addresses. It's just to ensure that there's a process that the local level has established for reviewing the forms and ensuring that the form itself is the federal form.
So when you say local level, do you mean at the SAU? I'm sorry to interrupt.
At whatever feeding site. So we do have schools that offer those meal programs, but then we also have summer camps. We have
Libraries.
other organizations that might participate and distribute food. And so if a student goes to a summer camp and they want to qualify, they can fill out, their families can then fill out the form for free and reduced, provide it to the camp, and then the camp would collect funding to support those meals for those students.
So which one of your agencies has oversight on that?
Department of Education.
Okay, so.
Over the meal program for summer camps, not of actual
Could
summer
it be
camps.
a directive from the DOE to perhaps, I know this talks about an opt-in form, could it be a directive from them to whoever it is that's in possession of these to perhaps a better education program to the parents, or when they fill out the form, could they opt in at that point to have their address sent if they wanted to? I don't know how that would work.
No, because the federal form, we're not allowed per federal regulation to alter
I
the
see.
form in any way.
Got it. Okay. Senator Alshaw.
Thank you, Mr. Chair. Thank you for taking my question. So in this bill as amended, it would have been an alteration of the federal form, correct? So if there were to be an additional form or email that would allow for, I would like the SAU to share my address with the Department of Health and Human Services for the purpose of my child receiving summer EBT. Would that create a space to collect that information and give parents information that there are summer meals available and here's how you get it?
Clarifying questions. So the
Yeah.
school or the district or the SAU would be responsible to provide the addresses to the Department of Health and Human Services?
That could be
Correct.
determined on the form.
Yeah, I mean, it could be determined on the form, but on the bill as amended by the House, lines 7 through 10, it seems like if the change were to be an additional form that says, I would like the SAU to share my whatever the SAU number is, to share my address for the purposes of feeding my child in the summer, would we be able to do that? Would that be a way to get that information and bridge the gap?
I appreciate the question. I would defer that to DHHS, but also to the school level, because at this point, Department of Education is out of it. It's something that's
Okay.
between the SAU and DHHS, and we wouldn't be involved.
Go, Brian. Let's go.
Okay, so
You're up.
if the schools are able to send addresses of individuals who are receiving free or reduced lunch, that would enable the department to send a summer EBT card to people. So the individuals who are receiving free and reduced lunch, who are known to the department because they receive SNAP or because they receive Medicaid or because of any other program tied to the department, they'll be automatically eligible. They are eligible already from receiving free and reduced lunch. But the problem is summer EBT is issued on a card, and that card has to be mailed to an address. So for everyone who isn't known to the department who receives reduced lunch but doesn't receive SNAP and Medicaid, that's the barrier that the sponsor is trying to address. So if that change was able to enable the schools to send the department the addresses, it would work. I am not sure if that's the case, because my understanding was that we couldn't alter the free and reduced school lunch form.
Okay, so I'm going to follow up here. Is there a barrier to sending, so the kids are receiving this service at their neighborhood school, and then school's out, so they need the card in order to show up at one of the places or the camp or the library? Is there a barrier to getting those cards to the school for parents to pick up or to be sent home at the end of the year so we can just continue services? Is that a possibility?
So the summer EBT card it's an EBT card similar to a SNAP benefit issued to the family, and they can use it at a SNAP enrolled grocery store to purchase food. So I don't believe we've always issued EBT cards to either a district office or for people who don't have an address, or for them to pick up, or to an individual's address.
I think probably this is going to be more complicated than the soft sitting in committee, so perhaps what I'm going to suggest is that one of us on the committee will take point on this and try and work through with you, or both of you, or whomever needs to be worked through, and try and find a resolution to this before we have to move the bill. Does that sound more reasonable? But Senator Reardon with a question.
Thank you, Mr. Chair. And it seems to me that the DOE is the convener of communication to all districts. That's an opportunity that you have. Are you willing, I get that you don't want to go in contravention of what your rules are around EBT cards, but are you willing to put that messaging out to all of your SAUs?
Oh, we have done that. Yes.
When
No,
we
we have been active in it. I mean, even when we're looking back to the pandemic EBT, and we've been partnering with DHHS for many years now to ensure that we're getting that out to all of the schools and to the superintendents so that they understand it for the schools that they're overseeing within their districts, that to get that information out. We do a lot of extensive outreach to the actual food directors and the staff that's working in the kitchens, because sometimes they have more hands-on with the kids. So yes, we've been definitely getting that information out, have been working on that. So that's definitely already happening.
One follow-up to that.
Sure.
So if it's a matter of the application that the family's going to fill out, stapling a notice to the top of that they get to check a box on that piece of paper, is that something that could be in your instructions too?
That's a great question. We could not staple it to it. Could we distribute it together at the same time? Possibly. We couldn't require them to do it, but we could make it available so that the schools then said, we're sending out this information to go home. They can be putting it also A lot of them go to electronic newsletters now. I mean, not many of them are sending paper copies home, but we can make all of that information, you know, available so that they're aware that the opportunity exists.
Is the free and reduced form a paper form?
Both paper and electronic. We have to make both available. We can't go only electronic. We
Okay.
can't go only paper. You have to.
So you'd have to make this new form available on both and say, please see additional forms or something to that effect?
Or it would be more of, where we would be referring them to the Department of
Yeah.
Health and Human Services to contact for
Okay.
that.
Who wants, anybody want to volunteer to take this one on? Senator Reardon does? All right. Great, thank you.
Thank you.
We appreciate it. Anybody else who wants to testify on 1727? All right, seeing none, we'll close the hearing. We're not going to exec today. I have a meeting that I have to make 20 minutes ago, which has been pushed off, so now it's 10 minutes.
15:11, yeah, I heard that too.
15.
Is this something we should just file in
Which one?
For when we get.
It's underneath the page.
Okay, yes, this will be when we exec. Yes, and that's, if you recall, 1511 was the Ag in the Classroom. Commissioner Jasper was going to provide some